we can say.
Good morning. Is that you, Josh?
Yeah, that's me. I was just checking that our sound was working okay.
Ah, cool. And Sean, is it?
Yes, it is. Good morning.
Sean's
Great.
here, and then
Okay.
my colleague Sarah is joining us virtually. She's Auckland meeting room.
Okay, so I'll label that. So what will I put for a label for that?
Just lay needs probably fine for.
Okay.
Got it. No, are we live? I think we're live. Hello, I take it everyone can hear me at the moment?
Yes, we can hear you, Commissioner.
Okay, so I'm coming across loud and clear. Okay. Okay, well, it's slightly early, but we'll get underway. I'm just checking if everyone else is ready to go. All right. Well, tēnā koutou katoa. Good morning, everyone. Welcome to the hearing. My name is Bob Nixon. With me is Commissioner Jane Sinclair.
Good morning.
And we've been appointed by the Queenstown Lakes District Council to hear and determine this application. As a result of the Council's response to the COVID pandemic, this hearing has been undertaken by Zoom. It hasn't been traditional practice, but given the times we live in, that's where it has to be undertaken. It's a hearing to determine whether or not consent should be granted to an application by Nature Preservation Trustee to construct a residential unit with associated earthworks of 492 Mount Aspiring Road, west of Wanaka. Now, the procedure we'll be following at the hearing will be familiar to many of you. I'll briefly outline how it will be conducted. And it's the same process as typically undertaken at council hearings with or without the Zoom process. So the applicant will present their case first. All parties should have received pre-circulated copies of the officer's report on the application, the applicant's evidence. Now, given that this hearing is being undertaken online, we'll be asking those presenting evidence to the hearing to either read or comment on a summary of their evidence. I'll just break there for a minute. I understand Mr. Hayworth is joining.
Good morning, sir.
Okay, Julian, you can hear me loud and clear?
Yes, I can.
Okay, thank you. I've just been beginning the process for opening the hearing and explaining the order in which the procedure will be undertaken. So I'll just briefly repeat that. So the applicant presents their case first, and they will present summaries of their evidence, not full reading of their evidence, as is usually the case. Following that, we will hear from submitters. Now, on that point, Mr. Hayworth, I understand you're the only submitter who will be appearing through Zoom with us today. There are two other submitters, Trilane Industries, represented by Mr. Todd, and Garth Hogan, who have submitted written statements but will not be attending the hearing. Now, following the submitters, we'll be seeking a response from the Council's reporting officer on matters that have been raised during the course of the hearing. And again, the reporting officers will not be reading their reports, which have already been circulated. And at the end of the process, the applicant may exercise a right of reply, which may be a summary at the end of the hearing or in writing following the close of the hearing. When it's the turn of a person to speak their evidence or submission, they may also comment on any matters raised in the preceding presentations by other parties. And as you'll be well aware, hearings commissioners do not necessarily adopt the conclusions that are recommended by the reporting officer. Now, given the limitations of this format, we'll try and keep proceedings reasonably informal, but there is no right to cross-examine other parties. In fairness to everybody, any disagreements with the opinions of others should be expressed during your presentation. Now, I understand that if you're not speaking, it's best to keep your microphone muted. Now, we haven't undertaken a site visit at this stage, but we will be undertaking it this Friday, and we will be observing the site from the water, from the Millennium Walkway, and by going onto the site itself. A written decision on the application will be issued within 15 working days of the close of the hearing, and the close of the hearing is taken as the time at which the receipt of the applicant's right of reply is received. The applicant or any submitters can appeal to the Environment Court if they disagree with the decision within 15 working days of receiving the decision. Now, at this point, I think we'll launch into the applicant's case. Now, I understand there's legal submissions being presented on behalf of the applicant. Yeah, I'd like to identify themselves at this stage, please.
Thank you, Commissioner. Josh Licky here, legal counsel for the applicant. Perhaps it would be helpful if I introduce very briefly the applicant team just before I kicked into legal submissions, if that's okay.
Certainly.
I've got with me in the room Mr. Dent, planner for the applicant, and virtually joining us from our Auckland office is my colleague Sarah Anderton, who's assisting me today. Her screen's named Lane Neve. And then the other witnesses who have filed evidence, Ms. Smithen, Mr. Humphreson, and Mr. Murray Orr are also online today.
Thank you.
We've filed written legal submissions in advance, which hopefully the commissioners and also the participants all have, which I propose to go through to start, and also some written summary statements from each of the witnesses. If anyone doesn't have those, please let me know and we can send them, but they went out to everyone yesterday. So starting with the legal submissions, and just as a reference point, really, the submissions often, if they refer to plans, there's a graphic attachment which was attached to Ms. Smithen's evidence, which is a good reference point, particularly around the planting. And there's also some architectural plans attached to Mr. Dent's evidence, a track change version of the conditions attached to Mr. Dent's evidence also, and a clean version of the conditions attached to Mr. Dent's summary statement. And Mr. Dent will be able to talk to some very minor additional changes that have been made to those conditions since the evidence in chief. Moving now to our legal submissions, which I won't read verbatim, but we'll just take the commissioners through, if that's okay. This hearing is in relation to a resource consent to replace an existing dwelling, as you've heard, and it's a family home in addition to a storage shed. And there's a theme throughout my submissions here that the fact that this is replacing a dwelling that's already in existence, and my submissions are a really critical part of your assessment of effects in this case. The property is located in an ONL, and it adjoins the Millennium Track adjacent to the lake. The current property, the current dwelling is also a large one, 635 metres in size, with lawns and curtilage. And importantly, the existing dwelling is visible from the Millennium Track, Lake Wanaka, and also Roy's Peak. And as I mentioned in my submission, that's particularly relevant to both the effects assessment, but also the objectives and policies assessment under the PDP. The proposal replaces the existing house, and as such, it doesn't introduce a new domestic element to the environment that's not already there. And it's been carefully designed to be in keeping with the landscape. And most relevantly, rounding it up, 67% of the dwelling is subterranean, and the above portion is therefore a similar scale to the existing dwelling. The dwelling's also been orientated in a way to reduce those key visual effects, and the materials and claddings have been carefully picked and designed. An important part of this proposal is the landscaping and landscape mitigation, a lot of which has already been undertaken and is well established, and that therefore is providing an immediate mitigation effect to visual effects already. Ms. Smithen can speak to this. There is an element of landscape mitigation that needs to follow earthworks, and that's on the landscape plans as stage 3 mitigation. And that one of the amendments Mr. Dent has to the conditions relates to ensuring that that is planted within the next available planting season of those earthworks or of construction being completed. Due to that large portion of the building being subterranean, there is a large volume of earthworks to complete the construction. However, this will be staged and remediation works undertaken as the earthworks are carried out. Also, due to the size of the site, effects can be internalised as much as possible. In particular, all of the cut and all of the earthworks are deposited on the site, greatly reducing or preventing altogether the transport movements of that fill. At paragraph 6, in my submission, this is a key effect for this hearing. There are some temporary visual effects associated with this construction. These will be limited to the approximate 2.5-year construction period, and will be mitigated by the planting, both that's already in place now and will follow. In terms of the broader environment, which I'll get into in more detail, the final dwelling will form part of a sequence of dwellings along the ridgeline within this ONL, and result in effects which are consistent in my submission with that existing environment. It's therefore, in my submission, appropriate to grant consent. I won't read the summary. Over the page 4, I've provided some more detail on the existing environment, which I won't repeat, other than to add at paragraph 12, which we haven't touched on yet. Access to the existing dwelling and the proposed dwelling is over a shared right-of-way, which our client has a legal easement over, providing for access and also maintenance obligations. This was previously raised as an issue by Trilane, but I understand from Mr. Todd's summary of submissions yesterday is no longer being contested as an issue. And as I mentioned at paragraph 13, this existing dwelling is a number of existing residents along the same ridgeline within this ONL, and more details provided by Mr. Dent on that and also Ms. Smithen. So moving over the page to page 5, the proposal that we're here to assess today. My client purchased the property with the goal of enhancing the environment, and it's a genuine desire of theirs. This is to be their permanent home. They're Wanaka locals and they wish to live on this site. They've already planted 4,000 native plants as part of that vision for the site, and the dwelling is the next step. Steve, the architect, will be able to speak to this, but it's an architecturally designed dwelling, most of which, or the majority of which, is subterranean, and the roof structure has a living roof to further mitigate those visual effects and landscape character effects. I won't read 16 and 17. I'm just providing some more detail there on the building design, which Mr. Humphreys can speak to. In terms of the volumes of earth, it's approximately 20,800 meters cubed of cut, and that will be deposited on the site. So the total earthworks is 2 times that, and that is to be deposited behind the property. And some schist outcrops are to be avoided through that process. And as I mentioned, that will significantly reduce the construction traffic by utilising the property for the deposit of that fill. There's proposed restrictions on heavy vehicle movements, which are outlined in the conditions, and it's, as I understand it, the only point of contention with Trilane is the the hours of those movements. And as I mentioned, it'll be through this existing right-of-way, which is already in place. The applicant has commissioned Acoustic Engineering Services, who have undertaken an acoustic and vibration assessment, and the application will comply with the noise and vibration standards in the PDP. And it's on that basis that the conditions around timing of construction have been proposed. And I understand that's been peer reviewed by the council, who support that acoustic assessment. As I mentioned, at 22, construction will be staged, and as a general observation, the effects of construction will reduce over time. Mr. Murray Orr speaks to this in his evidence. And ultimately, by stage 3 of the construction, the majority of those effects are internal to the dwelling. And then lastly, at 23 there, I've just reiterated the planting mitigation, which is important to this proposal, and there are conditions requiring irrigation of that over the course of the consent. The statutory framework I won't spend too much time on, other than to just reiterate at 24A in my submission, the word environment, the legal environment is critical here, and that the environment against which the effects of this proposal need to be assessed include the existing dwelling. It's a legal part of the environment, and it makes this application quite different to either a subdivision or a consent for a dwelling on a property that currently doesn't have one. Over the page, I've provided a high-level summary of the key effects as I see it for your consideration at this hearing. As I've mentioned, the existing environment is an important part of that assessment, and I've referenced some case law there that ultimately resulted from the Hawthorn case regarding the fact that the existing legal built form forms part of that environment against which to assess your effects. The first key effect is the landscape and visual amenity effects, as we're in the Mount Alpha ONL. And I've mentioned already the nature of that, and Ms. Smithen has assessed the proposal against the values of the ONL. And overall, at paragraph 32, Ms. Smithen's view is the effects on this landscape will be very low. There are visual effects from various viewpoints, and some of these are temporary and some permanent, and that's distinctions I've discussed further below. So firstly, on the construction effects, I've summarised there the earthworks volumes, and Ms. Smithen has assessed the construction effects, and these are provided in more detail in Mr. Murray Orr's evidence, so I won't repeat those. The construction area will be visible from parts of the lake, and I understand the commissioners are going on the lake on the site visit on Friday, although what will be seen at different stages will differ, and Ms. Smithen can speak to that. Moving now over the page 11, to permanent effects, so effects beyond that 2.5-year construction period. In my submission, these will be minimal, given that there already is an existing dwelling on the property, and it has a broadly similar sized above ground element, and there'll be further mitigation in addition to this existing environment by the existing and proposed planting. And ultimately, the earthworks effects, which are temporary, will not be discernible in due course due to the hydroseeding and layout of the fill. There is an element in this case of some mitigation off the applicant's site in the council road reserve, partially due to a fence that's in the wrong location. So the applicant has engaged with council parks and reserves. The reporting officer will be able to speak to this, but they've approved that mitigation planting, and the applicant has agreed to ongoing irrigation of that planting, which is already taking place currently, but it will be also insured through the conditions. At 41, again, I won't speak for Mr. Humphreson, but there is a difference in architectural style between the two buildings, although he did design design both, helpfully. But the proposal does use, as I've mentioned, recessive colours, an extended eave, which is important mitigation for glare effects, and also the landscaping proposal to further mitigate those effects. A key feature are subterranean portals, which contain a lot of the sleeping accommodation, and which will ultimately be covered in landscaping and lawn. So overall, Ms. Smithers' view is that the visual effects from the completed dwelling will be low to negligible. And I understand that Ms. Malsop for the council's broadly in agreement regarding the scale and the ultimate nature of those permanent effects. I won't read the next section. It's to provide some background to the difference between the temporary and permanent scale given the history of this application. Consent was previously granted on a non-notified basis for a proposal similar to this, and that was that non-notification decision was judicially reviewed to the High Court by Trilane, noting that Trilane are no longer seeking decline of consent in this case. But all I'd add, just for context there, is that High Court decision was about the council's treatment of temporary effects and their relevance to the notification assessment of no more than minor. And in my submission, it has limited relevance or no relevance to your considerations today. And I've just extracted a portion of the High Court decision, which does make the differentiation between what they were assessing being how to treat Ms. Malsop's assessment of moderate effects during construction, and how that is different to what ultimately is the council's assessment of the substantive resource consent. So I've just summarised that at 43. And the Court of Appeal, since that High Court decision on this application, has endorsed that approach regarding the treatment of effects at notification stage and for those temporary effects. But obviously the temporary effects are relevant to your assessment, but in my submission, they are just that, they are temporary, and that's an important lens on which to view those effects. And in my submission, they've been appropriately avoided or remedied through the proposed design and conditions. Over the page 13, moving to ecological effects. It's an important part of this proposal and a very important part of the vision of our client. As I've already noted, there's a total of 4,000 plants that have already been planted in 2017 and 19. On the planting plans attached to Ms. Smithers' evidence, they're described as stage 1 and stage 2. And Ms. Smithers will be able to take you to those when she presents. And that also includes a cluster of quite significant beech trees, which will ultimately form mitigation to replace some exotic trees that will ultimately be removed from the council's reserve as they are a pest species. The planting on the site complements planting undertaken on the council's road reserve by a local trust that has been maintained and irrigated by our client. And the planting is an important part of mitigation, both of construction, but also of the completion. And this planting will be retained through the conditions. I've summarised the construction effects in the next section. I don't propose to read that out. It just provides a summary of the nature of those effects. In my submission, they are temporary. It's a point of disagreement with Mr. Howarth, but I've given an example there of a board of inquiry that found construction effects of 6 or so years in the nature of a roading project, also as temporary. So in my submission, there's clear authority that a 2.5-year construction period is a temporary effect. At 52, I've just emphasised there, and a lot of this immediate neighbours aren't attending today, but the setback distances are an important mitigation of those construction effects. As I understand it, none of the neighbours' properties can actually see the dwelling, and also those setback distances are important to the management of acoustic and vibration effects, which has been further assessed in the AES assessment. And those effects will be ultimately managed through an environmental management plan, which Mr. Murray Orr will be able to speak to. As I've mentioned, the construction hours have been proposed to be limited through the conditions, and that's drawing from the AES assessment, which has been peer reviewed by council. Those construction hours, whilst it's not expected that they'll be utilised to their fullest extent for the whole construction period, as I understand, they are necessary for parts of the construction, such as delivery of concrete trucks during concrete pours, etc. The last construction effect I haven't spoken of yet is the dust impacts, which I've summarised at 55, and there's proposed mitigation in the form of irrigation sprinklers to manage that. I've gone on to summarise the relevant planning instruments for your consideration. The proposal is a discretionary activity under the PDP, and the applicant, and I understand council, agreed that there are no rule triggers in the ODP, and that these are no longer operative given the PDP triggers are beyond challenge. In my submission, the PDP policy assessment therefore needs to be undertaken importantly in the context of the existing environment. So the environment which includes that existing dwelling. At 59, I've provided a summary of that objectives and policies assessment, and I won't go through that. I'll leave that for Mr. Dent, other than just to highlight subparagraph G of this section on page 17, in that this is the policy that Mr. Houth has mentioned. It's a PDP policy regarding all buildings and structures and all changes to landform or other physical changes being reasonably difficult to see from beyond the boundary of the site. And this has been assessed by both Mr. Dent and Ms. Smithen, and linked to my earlier comments in my submission. This policy needs to be considered within the lens of the existing legal environment, which includes that existing dwelling, which already falls foul of that policy when it's considered on its own. But I don't consider that of a material to the overall objectives and policy assessment that the commissioners will need to carry out. And I've briefly summarised that at 61 and 62. Just relying on the relatively well-known authority of DI, that the objective and policy assessment needs to be a fair appraisal of those objectives and policies overall. In my submission, that's what has been carried out by both Mr. Dent and also the council reporting officer. Last and not least, but a defect that I understand hasn't been raised by submitters is the trigger under the NES of contaminated land, due to the fact there's an existing wastewater system on the site, and as such, there's a proposed condition to manage that, requiring an additional assessment in the future. I've briefly touched on part 2. I don't propose to dwell on it, in that this is one of the few applications that can fairly squarely apply the proposed district plan, and it's newly minted, and in my submission there's no need to go up to part 2, and that the plan provisions are complete, and there's no uncertainty. But out of completeness, Mr. Dent has provided a part 2 assessment. In the next section, we've responded to comments made by submitters. I won't go through those, in that they do repeat aspects of my earlier submissions, but they're provided there as a summary to respond to those concerns that have been raised by the submissions. Mr. Houth is here today and has raised the concern of cumulative effects. And so in response to that, I'd reiterate the fact that this is a proposed dwelling to replace an existing dwelling, and that it's not introducing a new domestic element in a cumulative sense, which is an important difference between this application and other applications that may be made in this ONL. It's 74, I've touched on a point that I understand isn't in contention anymore, which is the legal access to the site by way of easement. The 42A report writer and Mr. Dent are largely in agreement. There is some minor disagreements between Ms. Malsop and Ms. Smithen regarding the scale of some of those temporary effects, but they ultimately don't change the position of either the council or the applicant. So I don't consider there a particular moment to the substantive decision. Just to conclude, the proposal has been carefully designed in the special setting within an ONL. A key aspect is that subterranean portion, but there are other design aspects to further mitigate effects. Earthworks have been reduced as much as possible, including a staged proposal for those earthworks and on-site depositing of that fill. And this will be ensured through those consent conditions. In my submission, you can find that the proposal is generally consistent with the objectives and policies of the PDP and has limited overall effects in a permanent sense when compared to that existing legal environment, which includes the dwelling. And in my submission, I respectfully seek that you grant the consent for those reasons. I'm happy to take questions now or through the course of the day as we work through the applicant team.
Thank you.
Thanks, Mr. Leakey. I just have a couple of questions on the ODP. You say that, and I agree that the rules have gone. The objectives and policies, I heard you say, still have some relevance. What about the assessment that is attached to those rules? Are they still relevant at all?
It's a good question, Commissioner, and it's a question that I've been pondering over the course of preparing for this hearing and also speaking to Mr. Dent about it, and that I agree the objectives and policies are still in existence in the ODP and they haven't gone away, but because there's no rules, the weight that can be given to them in my submission is greatly reduced, and that's how I would suggest that the ODP be dealt with, is through a weighting method. I don't think it's particularly material in that the ODP and the PDP for this application take you in a similar direction in regards to the ONL, for example. But to go back to your question, given that the rule trigger in the ODP is now inoperative, then I think the assessment matters also have very limited weight, as I'd put them in a similar category as the objectives and policies. But as they hang off a rule and those rules are no longer operative, I don't consider you could give them much weight at all.
Okay, so just in terms of how we approach assessments like this, we have in the past sort of used the PDP assessment matters first and then look at the ODP assessment matters after that, given that there are quite a few similarities, and then sort of discuss the differences between the two at the end. Would that be an approach that you think is appropriate in this?
Yes, I think, I mean, the ODP assessment matters. Oh, sorry, I interrupted.
Sorry, but taking into account that weighting issue as well that you've said.
Yes, absolutely. So yes, I do think that's still an appropriate way to deal with the ODP and PDP. There will become a time in the future where the ODP will eventually drop away, but that hasn't happened yet. Therefore, I think for completeness, as Mr. Dent and also the council reporting officer have done, I think it's appropriate for the commissioners to go through that similar process. But as you say, my submission or my caution would be to put a more limited weight on the ODP, given it doesn't contain operative rules in relation to this application. But helpfully, I in my submission, that process will take you to a similar place in terms of the effects you need to consider. The situation may be different if the ODP and PDP pulled you in different directions.
Thank you. The other questions I had was around the framework as well, and where we're at with Chapter 3, and the priority areas and the mapping and the methodology. Mr. Dent has set out all the relevant objectives and policies in his evidence, but I just wasn't sure where we're actually at with them and how much weight can be applied to those. And I see that the mapping is due. Mr. Health has told us that it's due in June, I think, next month. And I just wondered if you had any update on that.
Yes, that's my understanding of the mapping as well. In terms of the objectives and policies in Chapter 3, they've ultimately fallen down from the Environment Court decision. So I consider they need to be given significant weight, and that ultimately they are a determination of the Environment Court. There is that mapping. I agree with Mr. Houth that mapping process is underway, but I don't see that as undermining or reducing the relevance of the Chapter 3 strategic framework that the court's put in place.
Would that be the same with Chapter 6? Is that those objectives and policies fallen down through the same court decision?
The same, yes. The Chapter 6 in the same respect, Judge Hesson's decision. Yeah.
Just a couple of other questions. One was on just the competing interests in the plan about. And I guess when we go on site, it might become clearer in terms of the PDP seems to have a driving force about maintaining openness where it's existing. And then we sort of have competing interests with the natural environment, enhancing planting and Indigenous planting and biodiversity. And I'm just wondering what your advice to us on those two sort of competing interests.
No, it's a good question, and Ms. Smithen may have some thoughts on this for you as well. I think, from my perspective, that the values and the nature of this particular ONL, including not just this site but the broader context of this ONL, are relevant. That include less of an openness element, particularly down on this lakefront area as opposed to the higher levels of the ONL, the Mount Alpha ONL. So I consider that's one way you can consider or strike that balance is to look at the actual values on the site and how they'll be impacted or otherwise. That would be because the plan does pull in both those directions. But in my submission, the openness is probably less of a relevant value for this site than those planting values. But Ms. Smithen's evidence does go into the relevant values, so she may be able to assist further when the time comes. I'd also just add, and I'm conscious to not harp on about it, but the relevance of that, what are the values in this case, does include the existing legal environment and that existing dwelling, and that's obviously relevant to that openness pull or driver.
Just on that existing dwelling, Mr. Leakey, I understand it was consented. I'm going to take a guess. I think it was 1998 or 1999. And
yes.
That was, I understand. I had a brief look at the decision. It was under a little bit of weight to the operative plan. It was just notified, I think, and there was most of it was under the transitional district plan, which had some limited landscape direction in it. I'm just wondering about so how much weight, I often hear from your submissions that you're saying that we can rely on that existing dwelling quite heavily, just even though it hasn't gone through the similar planning regime?
Yes, that's right, and that's certainly my submission, and I'll just expand on that a little bit further. In a way, the granting of that consent and then construction of the dwelling has codified or has meant it becomes part of that environment, regardless of what the planning drivers were leading to the grant of the consent and what the planning drivers are now. So in my submission, it really outlives or sits separately to those planning provisions that were relevant to its assessment. So it forms part of that environment, regardless of what was assessed at the time. The case, it's different potentially to say a very different situation to this, but say a consent notice that maybe would have been put on a title under a previous regime might be able to be treated differently or varied under a new regime. In that sense, the planning regime at the time is more relevant, but I don't see that as relevant to when there's an existing dwelling that's entirely legal and granted under a resource consent.
Thank you. And the other question is just back to that existing dwelling. Any protection on any of the existing vegetation on a planting plan or anything was associated with that consent?
It's a very good question, and I'll check back. My understanding is there isn't, but I'll check back on that and report at the close of the hearing just to confirm that. But as far as I know, there wasn't, and likely due to the point that you've raised, Commissioner, around the less stringent planning regime at that time.
That was all I had. Thank you, Mr. Ricky.
Yes, thank you. The two questions that Ms. Sinclair asked you, we had a brief discussion about these previously, so they covered my questions as well. Just make the point that I guess back in 1998, I strongly suspect it was a much more liberal planning regime that at that time. So while I'm taking on board your point that regardless of that, the existing dwelling formed part of the existing environment, any additional impacts of the current application are assessed under quite a different statutory framework than was the original dwelling. That includes the earthworks and such like.
Yes, I'd agree, Commissioner, and I think supporting that view are the particular triggers for this application. And that several of those would apply even if this was an extension to that existing dwelling. So I'm certainly not submitting that because there's a dwelling there, it's sort of a carte blanche, open door. Those additional effects do need to still be carefully assessed. It's just from a baseline, or wrong choice of word, but from a perspective of that existing environment.
Okay, thank you. Well, I think at this stage, would you like to call your first witness?
Yes, thank you, Commissioner. So in terms of the order, I'm proposing to set the scene first with Mr. Humphreys, the architect, and then Mr. Murray Orr will follow around project management, construction, temporary effects, then Ms. Smithen, and lastly, but not least, Mr. Dent. So firstly, Mr. Humphreys, who's prepared a summary statement, which he will read out and is happy to take questions following. I'll pass over to you, Steve.
Good morning.
Good morning.
So just to present my statement, my name is Steve Humphreys. I'm an architectural designer, having set up Sorted Architecture Limited in 2002. Of the qualifications and experience set out in paragraphs 2 to 3 of my statement of evidence dated 26th of April 2022. Confirm that I've read and agree to comply with the Code of Conduct for expert witnesses in the Environmental Court Practice Note 2014. In this statement, I provide a summary of the key points of my evidence. The existing dwelling is located on the northwestern shoreline of Roy's Bay on Lake Wanaka. It sits approximately 134 metres above the lake surface on top of a steep rocky schist escarpment. The property contains an existing house with a gross floor area of 635.9 metres squared. The existing house stands approximately 6.8 metres high from finished ground level. The eastern elevation is visible from Roy's Bay and is 34 metres long. The less viewed southern elevation is 27 metres long. I was instructed to design a proposed replacement dwelling for the property. My instructions were to position the home within the building platform, retain empathy with the landscape, and reduce the visual impact to the public. This was achieved by placing most of the dwelling underground with a green roof and creating cave-like portals that integrate into the existing landscape by using natural materials and landscape screening. Each portal has a large overhang with the doors and windows recessed back from the natural surface of the hillside so as not to be visible from below. The total above ground floor area is only 33% of the total GFA. And from the public view, the new home will visually appear smaller than the existing house. In addition to the substantial underground portion, this has been achieved by orientating the above ground portion on an east-west aspect, with the western end disappearing into an existing escarpment at the rear of the home and limiting the more prominent eastern elevation to 14.6 metres. The ground floor of this portion is set back under a shadow of the cantilevering first floor by 3.4 metres. The southern elevation first floor has been designed with glazing mainly limited to narrow slit type windows recessed within cordon steel shrouds to limit any potential light spill. These windows sit within a wall clad with custom designed glass reinforced facade panels with a 3D 20 to 40 millimetre deep random face pattern designed to achieve a camouflaging shadow effect, thereby limiting any glare or reflection. Further camouflaging of the southern elevation is achieved with planter boxes located along the eave and above the Corten window shrouds. Plantings will be trained to grow over a proprietary wire trellis system which sits proud of the facade panels. The roof of the first floor has large chiselled overhangs to the east and northern aspects. These overhangs help to soften the edges and create shadows across the low glare glazing. The main outdoor living areas are contained and hidden from public view within a sheltered north-facing courtyard, linking with the basement level living areas of the home. This space contains the outdoor kitchen, barbecue space, outdoor lounging, swimming pool and spa area. Garaging, storage and utility areas are also located on the basement level and are hidden from public view. Although the proposed replacement home will be visible from certain locations along neighbouring boundaries, it will not be visible from any of the neighbouring dwellings. The design and location of the new dwelling significantly minimises any potential effects of the neighbouring properties. And in conclusion, the proposed dwelling has been designed with a focus on reducing the visual impact on the landscape. Key design aspects which have assisted in achieving this include substantial subterranean aspect, the orientation of the above ground aspect being located to reduce dominance, and the use of cladding materials which limit the visual impact from the public view.
Thank you. I'll just begin with one question. I've been looking at the plans again last night. Obviously, architectural styles have evolved over the years, and there's quite a distinct contrast between the architectural style of the existing dwelling and the proposed dwelling. I appreciate that the east-facing facade, looking out towards the lake, is narrower, but in terms of impacts from the lake's surface, I know this was covered in Ms. Melsop's report. It's a much bolder design in many ways because you're going to have what would appear like a two-story high glass wall, whereas the existing dwelling is more fine-grained in appearance. It's broken up by the roof and the dormer windows and the other features of the building, whereas this is a very uncompromising glass facade. Can you comment on that any further?
I suppose when you view it from that prominent side, even though, you know, the dormers may break it up, it still appears as a block. You know, it's a square, a long rectangular block. So with the new home, with the glazing, we've specified a low glare glass. And yeah, I suppose it is a different architectural style altogether.
The comment was also made in the evidence that any lighting effects at night would probably be lesser because they're not, the areas behind the glass are not bedroom spaces. But one would have thought that occupants of the dwelling or people visiting the dwelling would want to use the living spaces at night, or have the living spaces at night, which would lead one to believe that there could be a reasonable amount of light spill from behind those large glazed spaces.
Yeah, the upper floor is purely office space, and a big part of that office space is a room, which will be probably the area that will be used most, and that space is contained. There won't be any light spilled from there. The rest of the lighting will be just low task lighting rather than full full lighting. You know, like it won't feel like a daylight sort of space.
Okay.
You know what I mean? Yeah.
Yeah. Okay, that's helpful. Now, I take it that the southern, it must be the southern facade of the building where the court and shrouds are going to be placed. Does that have a bigger profile than the current dwelling does? Or is it broadly the same?
It has a longer elevation than the current dwelling. Yeah, it does.
Yeah, thank you.
Thank you. I just had a couple of questions. I see that you were the architect for the original house as well. Were there, at that stage, were there any discussions on alternative sightings on the property, or was it always just been this particular site?
As far as I can recall, it was, yeah, definitely it was just the site always. The landscaping, I can't recall there being a landscape architect as such with planting. I think a lot of the planting was actually done prior to the subdivision by Wharekea Lodge.
And the other question I had is, you referred to a building platform in your summary statement. Do you mean that in the sense that that's the platform that the house is built, or do you mean it in the sense of a building platform under the plan?
No, not under the plan, just kind of the original the existing building platform that the existing house sort of sits on.
Do you know if there is an existing building platform for the house in terms of the plan?
No, I can't recall that there was.
Commissioner, I can potentially jump in and help there. As I understand it, there isn't a building platform in a operative district plan sense.
Okay.
Not, yeah.
There's quite a bit of talk through the evidence that the house is going to be visible, and Mr. Leckie's acknowledged that, and as has other witnesses, from the Millennium Track and from the lake. Is there any, was there any scope to shift it further back from the trail to reduce visibility? Would that assist in any way?
Well, there's quite a large hill that it sort of sits into already. So no, I don't think there would be. You would have to move a lot more earth to achieve that.
And is that staged, is that sort of when it starts to sort of protrude into that landscape or the glacier feature of the ridge?
Sorry, for the ridge behind?
Yeah, would it start sort of impacting the ridge?
Yeah, it would. I believe so.
Thank you, that was all I had.
Okay, thank you. Mr. Leckey, you don't have any further questions at this stage?
Thank you, Commissioners. We'll now move to Mr. Murray Orr, the project manager. Likewise, Mr. Murray Orr has prepared a summary statement and then can take any questions. Over to you, Jeremy. Oh, you're muted, Jeremy.
Good morning, everyone.
Morning,
Commissioner. Just reading from my statement, my name is Jeremy Murray Orr. I'm Project Manager for Triple Star Management in Queenstown, and I have the qualifications set out in my statement of evidence. I can confirm that I've read and comply with the Code of Conduct for Expert Witnesses in the Environment Court, Practice Note 2014. In the statement, I provide a summary of the key points in my evidence. The construction of the proposed dwelling will result in construction effects which are consistent with those which would be expected from this type of development. These include effects in relation to dust, noise, vibration, and traffic. Completion of the replacement dwelling is anticipated to take 2.5 years from site establishment, and this includes the bulk earthworks and all external works and site-wide landscaping. Construction effects will be mitigated through the implementation of an environmental management plan and a construction noise and vibration management plan to ensure the effects arising from the works are appropriate. The main reason for retaining the excavated material on site has been to reduce the effects of heavy vehicle haulage on the shared access road and the Wanaka Mount Aspiring Road. Construction of the proposed dwelling is to be undertaken in a staged manner so that the wider earthwork areas can be remediated as soon as practical. Remediation of the lake elevation of the basement and ground floor and the ridge behind the garages will be prioritised when these areas of the house are completed. The construction stages will include the following. Over the page, stage 1, site establishment bulk earthworks will involve the excavation of the driveway, water tanks, ground floor, building platform, basement excavation, and minor recontouring of the ridge. Our intention is to retain a screening bund to the lake face for as long as practical during this stage. The wider ridge line can be partially remediated, and the fill area to the west will be fully remediated and hydroseeded upon completion of this stage. Stage 2 is the basement and ground floor construction, including the lake-facing portals. This will commence immediately once excavation is completed. Simultaneously, the garage implementation shed to the rear will be constructed as well. Upon completion of the portals, the lake-facing elevation can be immediately remediated and landscaped. And similarly, the garage building, when that is completed, the ridge to the south can be remediated and landscaped. We expect construction of these areas to be completed within 18 months following site establishment. Stage 3 is the construction of the above ground levels 2 and 3, and this will continue for another 12 months. At this stage, the area under construction will be largely reduced from the originally excavated area, and construction activities will be contained. Much of the work in the latter part of stage 3 will be focused on the interior fit out, which has considerably less effects on the neighbouring environment than stages 1 and 2. In summary, it is my opinion that the temporary adverse effects of the proposed development, such as demolition, earthworks, construction noise, traffic movements, dust and vibration, can be adequately mitigated with robust construction management practices and the conditions of this resource consent. With these measures in place, the works will be able to be undertaken in a manner which ensures that the potential adverse effects are avoided, remediated, or mitigated. That's my statement.
Thank you.
Thank you. Thank you. I just had a couple of questions. One of them which you've answered, you've set up what's involved with each stage, so thank you. The other one that I haven't seen much information on is what's involved in the demolition of the house, and I take it that will be transported off-site. And if you can tell me a bit about what's planned there.
Well, I don't have complete clarification from the client whether he wants to remove everything or whether there is to be some salvage. Ideally, there will be some salvage because there's some nice sort of timbers and stone involved. But if it was to be a straight demolition and removed off-site, that can be conducted quite quickly within a sort of 1 to 2 week period following the decommissioning of services. If materials are to be salvaged, a lot of those are internal timbers and things like that, so they're pretty low temporary effects, and they can be wouldn't be noticeable outside of the dwelling.
Do you have any knowledge on how many sort of truckloads would be involved in if it was a straight demolition within that 1 to 2 week period?
No, I would be guessing if I gave an answer on that. It's something we could look into if required.
The other question I just had was on timeframes. The 2.5 years, is that taken into account sort of all these COVID delays and that I've been hearing through the media? Is that a realistic timeframe in terms of your experience?
COVID construction was a critical industry, so we didn't have too many delays during the earlier COVID lockdowns.
Or maybe supply issue delays, maybe that's what I was...
Yes, supplies, I mean, who knows, but I mean, the type of buildings that we do are very large and they take a long period of time, and we're very good at managing the supply of materials in advance, the procurement. So a lot of that would start early. We're not the sort of builder that rolls up to placemakers in the morning and orders 6 lengths of 4x2. So we think we can mitigate any supply issues.
In terms of your experience, is the 2.5 years sort of reasonably common for the sort of scale projects that Triple Star do, or is that quite a longer period than you normally would do? No,
we've just completed a large house in Queenstown that was 2.5 years as well. We've got another one in the construction that'll be longer at 3 years, which is larger than this. Generally, most of our builds are fairly large and involve all the right from earthworks through to landscaping and all the internal fit out. So we're there from start till finish. So I think it's a reasonable time frame. Yes.
And as a project manager, do you oversee that whole thing from start to finish, from the construction right through to the finished build?
Yes.
The only other question I had was just trying to understand the works to the ridgeline, or how much the sort of the glacial feature that runs behind the house that I think the garage seems to be butting into, or just don't you have much knowledge. I just wanted to understand a bit more about what's actually involved there.
So where the main areas of earthworks are probably where the long elevation, I don't know if you want to refer to the earthworks plan, page sheet number 3.
The earthworks plan is attached to Mr. Dent's statement of evidence.
You can see the large red coloured area, which is showing the area of cut.
Yes.
So the darker red is the larger extent of the cut, and that's probably the deepest area that needs to be cut into the hill. Where it's lighter shade, they're just slightly cut. So, some areas up towards the top of the ridge is less than 0.5 metre. It's just essentially a site scrape.
Right.
And then down in the bottom of the ridge where the back of the garages and the large precast panels from the main upper floors extend into it, that's sort of slightly deeper cut. So once that garage area, that long rectangular area, the outline that you can see is built, then that ridge line can be filled into the back of that. And as I say, in stage 2, partially remediated. So that wider cut along that ridge line can be remediated and reduced and contained to the upper floor areas, which are those 2 prongs which sort of cut back into the hill, and they'll be the last areas to be remediated in that stage 3. It was, I think in the original proposal, it was a lot wider and a bit further out, and the top of the ridge line was even being reduced. So one of the changes we made since that High Court hearing was to limit as much modification of that ridge line as possible.
Thank you. Thank you very much. That's all I had.
Okay, thank you, Mr. Orr. I think there are some questions I will have, but they'll be probably directed more at Ms. Smitham and the planner, but that's very helpful. Thank you very much.
Thank you.
Thank you, Jeremy. Now, moving to Ms. Smitham, who has also prepared a summary statement that includes a couple of amendments Ms. Smitham would like to make to her evidence, and they're described at the start of the summary statement. Over to you, Nikki.
Thanks, good morning.
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 Yes, as Josh mentioned, I have a number of corrections. Firstly, relating to earthworks volumes, and in the graphic attachment attached to my evidence, sheet 19 specifies the volumes that I understand have been updated since I've prepared the GA. So if you can disregard my sheet 19 and refer to Mr. Dent's appendix for the earthworks, that would be more accurate. And also in my evidence, I refer to construction time frames, and I understand these are at 2.5 years rather than 3 years I've stated, and that's in paragraph 70 and 151 of my evidence. And just as I was listening to Mr. Humphrey, I note that he has said the eastern elevation is 14.6, and I stated as 13.5 in my paragraph 25. So I think it just depends on how you measure, whether you measure them at the ground or the roof, including the roof overhang. So that's where that discrepancy falls. So I'll just read through my summary statement. My qualifications and experiences set out in paragraphs 1 to 4. And I've already covered off the correction. And I just provide a summary of the key points in my evidence. That the proposal is a replacement of an existing traditional 2-storey dwelling with a large modern architecture design dwelling. Although the replacement dwelling will be substantially larger in building area, 66% of the building will be subterranean, and the built form will appear as a 2-storey dwelling in a similar location to the existing dwelling. And as it's been mentioned before, the main point is that above ground proposed dwelling will appear similar in size to the above ground existing dwelling. And that's really, I'm talking about the visible portion of the house as you see it from the public realm along the track and out on the lake, because the rest of the house is just recedes back into the site. The proposed replacement dwelling is situated on the western edge of Lake Wanaka with the backdrop slopes of Mount Alpha and Roy's Peak between Waterfall Creek or Ruby Island Road and Ironside Hill Trig A3PC. This is within the rural zone classified as the Mount Alpha ONL. The area is characterised by low density development on large rural properties, including vineyards, rural living, visitor accommodation and pastoral farming. It's punctuated by amenity planting and increasing areas of native planting along the Wanaka foreshore and lakeside ridgeline. The key attributes pertaining to the receiving environment are the broad scale, highly legible glacial landforms, aesthetically appreciated interplay of large scale mountains and lake setting with a perception of high natural character, a highly scenic outlook, openness and a rural but obviously domesticated character, which is especially evident where there is a prevalence of exotic amenity trees clustered around dwellings. The lakeside margin in particular is becoming increasingly less open in character as revegetation planting along the lake edge continues to establish, including that undertaken on the site. Of key relevance is that the character of the lakeside setting, the existing two-storey dwelling and other dwellings along the ridgeline are part of the existing environment along the lakeside section of the Glendew Bay track, which is also referred to as the Millennium Track, and provide the context for the assessment of effects arising from the proposed replacement dwelling. Potential landscape and visual effects are most likely to arise from changes to the ONL values, including rural and natural character, and visual amenity arising from the replacement dwelling, associated earthworks during construction and the proposed vegetation. I consider that rural character will be maintained by the proposal with areas of fill reinstated as pasture and the proposed dwelling confined to the ledge that currently contains the existing dwelling within the site. Although the excavation and earthworks will be substantial in quantity, feature areas of schist rock will be avoided and fill will remain on site and will be spread within a localised gully and reinstated as pasture. I'm confident that the earthworks will not adversely affect the existing legibility values and character of the modified ledge landform or fill areas to any more than a very low or low degree. The proposed revegetation has and will continue to enhance the natural character values relevant to the ONL and the ecological diversity of the lakeside margin. Despite the revegetation reducing openness to the lakeside ridge, I consider the improved natural character to be an appropriate outcome along the lake frontage, which will also contribute to a district-wide benefit of enhanced ecology in the area. Visual effects are landscape effects experienced visually. The key viewpoints are limited to a short 1.2 kilometre section of the Glendew Bay track, the surface of the Lake Wanaka up to 1 kilometre offshore in the vicinity of the site and Ruby Island. The degree of visual effects takes into account the proposed mitigation, and that being the bulk of the building being the bulk of the dwelling, being underground, the use of recessive materials and colours, the repurposing of schist cladding and timber, Corten steel window shrouds, generous eaves and roof gardens, the hydroseeding of exposed earth, the partial screening by on-site vegetation, and the proposed revegetation that will continue to reduce visual effects as it matures. This mitigation, along with the limited view catchment, the massive scale and panoramic extent of the view in comparison to the small scale of change, the general focus of the view to the mountainous skyline and lakeland interface, and the activity the viewer is engaged in will result in very low visual effects. While the replacement dwelling will result in very low to low moderate visual and landscape effects during the construction period, these will be temporary and increasingly diminish over the construction period. Site observations and visual simulations demonstrate that the proposed replacement dwelling will be visible to a similar degree as the existing dwelling. In my opinion, this means the proposed replacement dwelling will be reasonably difficult to see, taking the existing environment, context, and all factors into consideration. Over time, as the native vegetation grows, the replacement dwelling will become increasingly more difficult to see. In my opinion, the effects of the proposal bring the overall difference in effects on landscape values between the existing and proposed dwelling within the same site and nominal building platform will be very low. So in conclusion, I've concluded that overall effects on the ONL landscape values, including natural and rural character and visual amenity, will be very low because the proposed dwelling is a replacement of an existing dwelling, is located in a similar position. Earthworks will be largely confined to a modified landform, avoid schist outcrop features and other obvious glacial features within the site, and the existing and proposed revegetation will increase natural character values within the lakeside setting. I'm happy to answer any questions.
Thank you, Stephen.
I can talk through the landscaping plans if that would help.
Actually, would help. I think that would be very helpful.
Yeah,
Yes, thank
please.
you.
I don't actually, I'm not very technical, so I'm not sure I can share my screen. Is there any?
I can perhaps jump in just to orientate the document. It's attached to Nikki's evidence in chief, so that's probably the best reference point for the virtual room to go to. And Nikki, you could walk through that.
Would that be, would that be
Page 20, sheet 20.
Start on 20, 21, 22. Would they be the best ones? 23?
Yeah, 20, 22, definitely, and 23.
Have them both.
Certainly appreciate Zoom is not an ideal medium for doing this, but yeah, do a bad job.
So I was hoping we'd break for morning tea and I could get someone to just sort this for me.
Well, if that helps, actually, that would be quite convenient for us at this time. Because I think it is
Excuse me, Bob, could I interrupt? When I get this information, the correct map, I can share my screen.
Oh, okay.
I'm just looking through now. So Nikki, which map was it, sorry?
Sheet 20 of my graphic attachment.
Okay, so what is that in the applicant's evidence?
Yes, Trish, Josh, it's in Nikki's evidence and
yeah, I'm in there. What number? Oh, I see. 20 of that,
yeah,
right?
Down the bottom right of the other page numbers on page 20 or sheet 20.
What number is it in the applicant's expert evidence? Sheet.
I think that was it, Trish. Oh no, hang on, I can probably tell you.
Saying sheet 20.
It's the appendix to my evidence.
Hang on, I think it's 119, 118, 117, 115 maybe?
So Nikki's evidence starts at 174.
Okay. Things out of my folder, which is not helpful.
Trish, it might be page 239 on your pagination
Okay.
system.
Right, 236. So I might just have to get my colleague to give me a hand to get this on the screen.
Take a break then.
Should we take, is it convenient to take a break?
Yes, it would be good time to do that.
239, was it, Josh?
Yes, I think that's sheet 20.
Existing and proposing planting staging plan.
I've got 237, applicant's expert evidence, page 20.
Yeah, so
That's the right one.
37.
Okay, right. So did you want me to try and get that up now, or do you want to have a break?
Take a short break.
Trish, there's a few of them. We're going to need to go.
Yep, I'll have them. I'll have the whole document up so we can just change pages. So how long of a break, Bob?
Would 5 minutes be enough?
Yep, that'd be great. Thank you.
Okay, thank you.
Oh, sorry. Hi, thanks. Much better.
I'm happy to make a start. I'm just wondering, okay, we're all here.
Can you hear us now, Ms. Smithson?
Yes, I can hear you. Yes.
Nikki, just let me know when you want me to flick to the next page. As the document's quite large, it sometimes just takes a moment for it to
load.
Load, yeah.
Thanks, Trish. Okay, so just by way of background, I didn't prepare these plans. They were prepared by Plot Landscapes, and I liaised with Annabelle just to really tweak the landscaping so that it was just to clarify a few points, and just as a proposal was slightly more modified in terms of the earthworks, and we added more planting to address those effects. But as you can see from the concept plan, we've captured broad areas of planting, and I think our staging plan and existing heights of the vegetation plan will show what's been planted when and the height that vegetation has reached. But this is the overall plan, and if I think my cursor might show on your screen as well, if I can get mine to work. The building is outlined. There is a green roof proposed over the underground portion of the dwelling, and the portals, you can see planting between each of the portals. The driveway comes in, and the quite large established beech trees are retained, and the driveway has been realigned to avoid the removal of those trees, because they're quite close together, and the current driveway actually goes through the middle of those trees.
Excuse me, Nikki, just a quick question there. The driveway bits to be removed, is that the grey with sort of like a hatching over it? And the light grey is the proposed access? Arms sticking out there. Is that the bit that's going, is it?
The driveway that's going is not really shown, because it's partially overlaid underneath the more solid grey. The other areas are tracks that will be added as proposed, really, because at the top of I can't really get this right. See where my cursor is, this area here, down here will be an area of fill, and that's just providing access down there. And then this other track is essentially a farm track, will be a farm track, and to access the area of fill that's going in the localized gully behind this main ridge line, which you'll see the red line is the main ridge that's being retained, I think, that Steve was talking about. And where there is cut into this hillside and the contouring occurs, this area of green vegetation is proposed as planting. So we've got some larger tall beech tree mix and shrublands going up there, and that will form a green backdrop to the dwelling.
Excuse me, Ms. Smith, are you using a cursor on your map? Is that what
Yes, I am. Can you see that?
I'm not seeing that at all.
Okay, I'm not sure. Probably because I'm not sharing my screen.
That would be very helpful for us.
The other alternative, possibly, if you can't do that, technically, would be just to perhaps, we can see the colours very clearly.
Okay, so the green area that's to the right of the ridge line that goes that shows the ridge line. So behind the house, and there's an area of green vegetation with other patches of vegetation. It's mainly shrubland with some tall beech trees included in that area, just as a backdrop to the house.
And that's all new planting, isn't it?
That's all new planting, and that'll be established fairly quickly, as I understand it, as part of the initial stage. And once the earthworks are done and recontouring occurs, then that planting can happen within the first available planting season. But in the interim, it's going to be hydroseeded. So not that you'll really see that ridgeline from the public areas anyway, because it's quite a long way back into the site, so you don't actually see it from the track areas. You will see it from the lake or Ruby Island.
Okay.
Marginally, but because it's set back into the site, yeah, it's not obviously visible.
Yeah, so it'll form a backdrop as seen from a distance would be probably.
Yeah, that's correct. Yes. The exotic trees, which are just almost a black graphic, appear as a black graphic on below the house to the south. They're all being retained. So they're large clumps of exotic trees just below the house, not below, to south of the house. Yeah. That's on more or less on the existing ledge of the house. And then the planting in front of the house that's referred to or indicated as an existing native vegetation, that is all the that captures the groups of vegetation that's already been planted, and that is a mix.
Right, so that's a lot of that will be the 4,000 tree plants that have already been established, will be in that sort of khaki green colour to the east and south of the dwelling.
That's correct.
Big patches of it. Yeah, okay, understand that.
There's something that's popped up on my screen that's obscuring my view. I think it's on Trisha's screen. Oh, thank you. Yes. And you'll see, and then the darker green is that is the existing. It's quite hard to differentiate sometimes. There's the existing vegetation, exotic vegetation along the boundary line, and then the reddish brown colour is the outside the site is the takakano planting. So that all remains. Some of the existing exotic vegetation, which is key to the right there, includes the Douglas fir that will be removed. There's also, in my evidence, I've included a few photographs of, and they're not really shown on here just because of the difficulty of locating. Well, you'd have to GPS every single tree, but there is some rather large established beech trees in behind the existing conifers at the northeast corner of the site and along that boundary. Okay,
that's up towards the northern boundary where those two arms come off the farm tracks you're talking about.
That's right, in the northern corner of the site, the apex of the site, I guess.
Sorry, where are the? Just clarify for me. Where are the north? What are they? Douglas firs that are going to be supplanted, if that's the right word for it, by the natives. Is that those sort of blobs to the south of the house there, with sort of like individual trees, sort of.
No, the conifers are at the apex of the site, the northern corner of the site.
Okay, right,
And
understood.
the apex along the boundary of the site with the Millennium Track or Glendow Bay Track.
And Nikki, Josh here, I'm wondering if viewpoint 7 might be a helpful context in relation to that question from the Commissioner, which is on your sheet 34, that just shows the conifers in the visual on sheet 34, just to give some context to that.
Yes, I think it's a good viewpoint to look at, actually.
Yes, yeah, I think a lot of this will become clearer once we get on site. It's just that we're sort of labouring under a slight disadvantage in that respect, but no doubt that'll become clear on Friday.
That's right. And the site is quite complex. It's quite the scarp face towards the Millennium Track is relatively hummocky. It does have some outcrops of schist rock, which you see in grey, with a grey colour graphic, mainly below the portals. Between each of the portals, you'll see a graphic that shows advanced grade beech trees. So they'll be planted once, I think, stage 2 earthworks has been completed, and there'll be some retaining of so the portals will be a schist faced opening with the recess back, as Steve said, with the and they'll appear cave-like from
sheet 21. Sheet 21 may assist the virtual room on that point. It's just the next sheet, Trish.
So if we go to sheet 21, this is a blow up essentially of it's not the same orientation as the previous sheet, so it's just twisted round just to fit it on the page, but you'll see the detailed planting plan, the portals, and so it's just immediately below the portals and between the portals, and we've got advanced grade beech trees which will be planted, and to retain the areas between the portals, obviously there are wings coming out, but it will still be a relatively steep slope, so that will be retained with any schist boulders that are excavated from the site, and more of an informal layout rather than, so it'll be planted between those boulders rather than a constructed wall for retaining. It'll just be boulders placed informally as a step, and that's just to be consistent with the schist outcrops that you see below the portals.
Yeah. So the terrain actually drops fairly steeply from the front of the house, looking at the contours.
That's correct, yes.
I take it the planting is designed to ensure that from people, I think there's bedrooms behind the portal, so they'll have the view out.
That's right, yes.
Tree in front of their view, as it were.
That's correct. So the large grade trees are essentially between the portals, so they'll grow up and soften the upper levels of the house as well, because they'll reach substantial heights, and the remaining planting is a little bit lower. There are beech trees scattered all throughout the existing planting and proposed planting.
Okay.
So it's not intended to screen the house completely, because obviously they want views out, but the terrain and the planting will screen it from certainly the track. You'll still see it from the lake, depending on where you are on the lake.
Okay.
And you can see the existing house quite clearly from the lake too. So if we turn to sheet, if you're happy about that, moving on to sheet 22. And this sheet just explains the areas that have been planted already, and the grades that were planted, and what heights they've achieved. And the areas that are still to be proposed, areas that have been retained, and so on. So you can see the red dashed outline on the plan, area G, that refers to the previous plan we looked at that shows the detail planting below the portals. And area F, which is immediately behind the house and will be undertaken post-construction, post-earthworks. So in the main, a lot of the exotic deciduous trees will be retained, and certainly the native vegetation is establishing well. It's irrigated, there's pest control, so it's establishing well.
Just in terms of the planting and the earthworks, the total area of the earthworks is 1,700 square metres, 17,000 square metres, but not all of that would be worked at the same time, one assumes.
I think the actual quantity is 20,000.
Yeah, I think that might be right here from what we heard this morning.
The volume and the area that it's spread on, yes. So as I understand it, from Jeremy, the staging overlaps, and as soon as one area is ready, one area of earthworks is completed, the finished surface will be contoured and hydroseeded and all planted within the first planting season. So there'll inevitably be some overlap.
Yeah, understand that.
And as Jeremy said, they're aiming to retain a bund or buffer to the track as long as possible. So much of the earthworks that takes place internally and at the back of the ledge, it will be very difficult to see. And then obviously the underground part will be quite difficult to see too.
Right, yeah, understood.
So sheet 23 actually sets out the average of the plant heights that have been achieved, and that was when I was on site as at February 2021. So, you know, it's another year, 3 months later. They've established that they're taller now.
Are they irrigated by any? I presume they're not.
Yes, they are all irrigated.
Oh, they are. Okay.
Yeah. And I believe that the Takakano planting outside the site is actually also irrigated by the applicant. That they have access to irrigation, and that has been agreed on by the applicant.
Yeah. So
the planting on the site is very consistent with what is happening all the way along the Glen Dubé track. There's been substantial areas of planting by other property owners along this lake ridge, where they've undertaken development either as a condition of consent or voluntarily. They've established native planting along the scarp face too. So the character of this lakeside setting will progress from being open in character to very much an enhanced natural character setting.
Can I just ask you a question on that? Because to me, that's a very large issue for our considerations. The district plan, as I read it, has sort of an outcome that it wants for the ONL is to maintain the openness that exists if it's existing. And then I hear you say that you did just say that it is an open character at the moment in this particular area, and that it's going to change to an enhanced natural character. I just want to know what your understanding of the plan is. What does the plan actually want to achieve in those ONL landscapes?
Well, I think the policies are a little bit conflicting. The open character is a managed landscape. If that landscape was not managed, i.e. grazed or managed by farming, it would not remain open. So that's one aspect to it. But appreciating that openness, the open character does contribute to high legibility values where we can see, we can see the formation of the landscape, we can understand it. You have those wonderful schist outcrops that features within the landscape, and it's very much a Central Otago landscape. However, there are pockets of native vegetation and that are equally appreciated, and mainly ONLs, perhaps more pristine ONLs than the ONLs immediately surrounding Wanaka. So yeah, it's a bit of a conundrum. I'm personally of the opinion that in this setting, it's a lakeside setting. You have got development occurring as a sequence of dwellings along the lakeside ridge, and I think that the lake edge appropriately should be planted. It should reflect a more natural character. We should be establishing planting that would have been there originally.
One aspect of openness is, I can't quite think of landscape terms at the moment, but openness is expressed in one respect as lack of buildings, in other words, lack of structures, rather than openness in terms of like a tussock landscape.
That's correct, yeah.
I recall, because I've been involved in at least 2 other hearings relating to this area immediately west of Wanaka, and I think the Environment Court apparently said some years ago that this area is distinct from much of the rest of the ONL around the broader Wanaka Lake environs, but it's too small to be a landscape unit in its own right. I think that's what the court found. So this area here, of which this site is part, but it's almost like a subset of the ONL really.
Yeah, it has been captured in the Mount Alpha ONL, but it is distinct in character, and I think I mentioned that in my evidence, particularly where you traverse along Wanaka Mount Aspiring Road to Glendhu Bay. The area between the road and the lake edge is quite distinct in character to the open character of the Mount Alpha always peak slopes, which are high country farmland. This area is more domesticated, and it is really noticeable, especially when you go out onto the lake, you'll see the scattered exotic trees along this lake edge that really indicate where development or buildings, dwellings, lodges are located in the landscape. I think that so yes, it is really a little wee subset of the ONL. That's not to say it doesn't have values, outstanding natural values. It does, primarily because of its lakeside setting, and to enhance that lakeside setting and I guess reduce maybe the perception of built form in the landscape, which is already existing. We've got an existing dwelling on this site. Then, to my mind, it's preferable to have that revegetation occurring. So yes, in answer to your question, I should actually say that I think at one point there was a decision that differentiated between open character and open space, where open character was a lack of trees and open space was a lack of buildings.
Yes, that's what I was thinking of, because in some respects there is a bit more like the Diamond Lake area, which is also hummocky, but I imagine that doesn't come across as an open landscape, tusky landscape either. There's quite a lot of shrub vegetation on it.
Quite a lot of exotic stuff, quite a lot of willow trees and other exotic vegetation there, which is a bit of a shame, but yeah, no, it's not as open. I mean, and we, let's face it, we all appreciate the open tussock grasslands, the alpine areas, certainly you'd call those open landscapes. They're just stunning. And but yes, they have a high degree of natural character because they are not managed as farmland and they are comprised of native vegetation. Whereas this landscape is more of a managed landscape, and even the slopes of Mount Alpha, they're more managed in terms of they're farmed. They might even be top dressed. They're not exclusively native because they've got exotic pasture on them.
Yep, yes, thank you.
I just had a couple of other questions, Ms. Nathan. Not much has been said about this proposed four-wheel drive track up the slope. I just wondered how visible that would be.
Again, I understand that's to enable the fill to be deposited, and that track is internal, and I think you would struggle to see it from anywhere. I mean, farm tracks are located within the site and within other areas of the O&L on farm landscapes. So given that it won't be a formed road or anything, it would just be, as I understand it, a farm track.
Just the other question I had was regarding curtilage area. Is there a proposed sort of amount of curtilage area, or is it just, yeah, that was really my question. It just refers to curtilage area. It doesn't refer to a size or a specific area, and
No, that's a good point.
And I know it's an issue.
Sean may be able to answer that. I understand the curtilage area would be largely located behind the roof garden of the underground portion of the site and around the pool. And really where the exotic trees are south of the building. I don't see there being any other curtilage areas per se, apart from, I guess, the lawn will be reinstated in the top north corner of the site. And in a sense, this whole site is the site. The area immediately surrounding the building is existing curtilage already. There's quite a exotic garden area, if you like. But because it's really transitioning, it's certainly in front of the house to a more naturalistic landscape. The curtilage area is quite confined.
Yeah, that raises an interesting question. I think it might have come up in Mr. Howard's submission about clutter, and generally with applications in the Wakatipu Basin, for example, a curtilage area is defined where clutter, however you define that term, is going to take place. It can't occur anywhere. I don't know whether you have any thoughts on such a control or any type of control over that would be appropriate here. Almost feel guilty saying this, but generally these very high, this is obviously an extremely expensive top of the market type of property if it was developed. They don't tend to store containers on the property and things like that. It doesn't tend to happen with properties of that nature. But is there a case for, do you think, for restricting storage outside? I know they're going to have a very large garage, but...
Yeah, I was just going to say, I think the large garage pretty much will capture all the curtilage area. I mean, the existing house has obviously a clothesline, and there is a large tunnel house just along the base of the ridge line behind the exotic trees, and there is on the if you go back to sheet 20, the curtilage area is labelled on the plan as being those areas north and south of the site, captured by the green lawn areas. Right. So from my understanding, that would capture the curtilage areas, and the rest of the where the native planting or revegetation occurs is simply so steep that you wouldn't be using that for your clothesline or anything like that.
No, I understand that.
I just had a couple more questions. Just the feasibility of establishing the planting while it's still a construction site. Have you had any experience in that? And what's sort of how much assurance can we get that the plants will survive living with construction?
We just say avoid, avoid, avoid. I don't think that that planting in areas of construction is particularly feasible. In this instance, though, because it's being managed by Jeremy, who is very familiar with these projects, and there is hydroseeding occurring, there'll be irrigation, the irrigation will be maintained to the existing planting, as I understand it, and I'm assuming that areas of planting would be fenced off, or with by appropriate means. Certainly, the planting won't occur until the earthworks is completed. So I don't think that I think it can be managed on this site quite well, because there are discrete areas that can be planted that aren't going to be in the way of construction, ongoing construction. So they'll be planted after the construction is more or less completed in those areas, the earthworks completed. So, for example, once the portals have been done, the planting can occur between the portals, and then that's not really going to be interfere with any ongoing construction, as I understand it. So I think it's achievable.
Can I just jump in there, Nikki? I think it's completely manageable to protect any areas of planting during construction. It's such a large site that areas that are planted, such as the portal areas and the ridge line, they can be fenced off, and just they're no-go areas for subcontractors and workers on site. So yeah, I think it can totally be well managed, and we are definitely keen to get that planting underway as early as possible during the build.
Thank you. And just my last question was, it's been a reasonably regular occurrence in hearings, is the fire risk of certain plants, and I just wondered if you had any thoughts on that, if any of these plants have a higher fire risk than others?
Well, certainly the Kānuka species do. The other species less so. Given that there's, well, I'm assuming the house has some sort of fire sprinkler system throughout it, but because the landscaping is irrigated and there'll be somebody living on site, I think the fire risk is minimal. But generally we would look to remove any areas of Kānuka or Mānuka at least 30 metres from a dwelling. In this instance, I guess the underground part of the building is stone and concrete, so unlikely to be that flammable either. So yeah, I think the risks are minimal.
Thank you. That was all I had.
The only other remaining question I think I've got is relates to visual simulations, a particular viewpoint 9, which I think is taken from, I presume, Ruby Island or near Ruby Island. And looking across, and looking at those, you've got the existing view and visual simulation below it. So that second one is showing what the vegetation pattern would look like once it's fully established. And that, a lot of figures have been bandied about, but that's the sort of thing you'd be expecting after, what, 5 years after construction is completed. Is that correct?
Well, we generally show the simulations at 5 years and then 10 years.
Yep. Yeah, this one's on page, yeah, it's called Viewpoint 9 Visual Simulation.
So there's viewpoint 9 proposed 5 years revegetation, and so if you turn to the page 40 that's the one there, 5 years.
So that's what you'd expect to see.
Yeah, it's irrigated. Yeah.
So you may recall me asking earlier. You can just make out on the top one. You can see the existing dwelling. It's almost right in the middle of the photograph, sitting on the bridge, sitting on the hilltop there.
Yes.
In the proposed dwelling, you've shown it as that dark area.
That's correct. Mainly because the top story does have projects above the bottom story slightly. So the recessive colours used are quite are dark, obviously. So it does mean that the building will recede quite a lot into the landscape. And you can see in this viewpoint the value of the vegetation behind the dwelling as well. Yeah,
there was some interesting comments made in Ms. Melsop's evidence. I think I still got the impression with the applicant's case that not exactly being disparaging about the existing dwelling, but I think looking at that, and from my visit to Mawaho, looking at it from the boat, is that the existing dwelling, in fact, isn't all that incompatible with the existing landscape because it's quite fine-grained. That's
true, yeah.
Roof structures and the materials it's made of break it up quite a bit visually. Yeah. Whereas the proposed dwelling is going to be a fairly substantial glass wall. So do you think that is a reasonable representation in that simulation there of what it would look like?
Well, I can tell you that one of my colleagues, Jeremy, who prepared these visual simulations, is completely anal about accuracy. And I can assure you that these were modelled and are very accurate according to the architect's design.
Yeah.
So he will have endeavoured to show this. I mean, obviously, and what I've noticed as I was out on the lake the other day actually for something completely different, just even to look at some of the other jobs I've been involved in, and also the existing dwellings that face the lake, and looking at what is more visible and less visible. And I think I've included in my evidence that some of the dwellings that are more modern and less traditional, with large expanses of glass, are not as visible as you think they might be. And also in this case, the top story protrudes over the bottom story, so you're not getting a 2-level expanse of glass at any one time. You know, the ground floor will be shaded a little bit by the overhang of the top floor, and there are generous eaves and there are roof gardens with vegetation that will hang down. So I'm confident that the the glass won't cause an adverse effect. And I'd just say that since, I think since Helen had looked at this proposal, we have included quite a lot more vegetation behind the house, because it's sometimes of the year without it, and it's sometimes the year the back slope is quite light in colour, where the vegetation burns off. And so if the house is quite dark, it can look like quite a sharp angle against that backdrop, and that's why we've introduced the backdrop planting to soften that effect.
Yeah, no, sort of part of the reason I asked that question was that my wife and I reside in Fernhill, and in the evening, if the sun's shining, you can sometimes get a very intense reflection from a dwelling in Jack's Point.
Yeah, I think that will always happen. I don't know how avoidable that is. And every time I drive into Wanaka and see that it's not in Queenstown Lakes District, but the development on the hill across the valley, and sometimes because it's 4 o'clock in the afternoon, there is quite a lot of glare from some of the windows there. But I guess it's fleeting, it's transitory, and yeah, similar to glare off that you might get of a passing car or anything really. It's not long lasting.
Okay.
No.
All right, well, thank you, Ms. Smith. That's very helpful. Thank you.
Thank you. Thank you.
Thanks, Nikki. So moving now to Mr. Dent, who has prepared a summary statement which he'll present, which also includes the latest version of the conditions.
Okay, well, what we'll propose at this stage is to take a short adjournment before we finish with your last witness. So if we break for 15 minutes from now and come back to Mr. Dent.
Yes, sure. Thanks.
Okay, Mr. Lecky.
Yes, thank you, Commissioner.
Okay, so we're now moving on to Mr. Dent's.
Yes, that's right. So Mr. Dent's provided a summary statement as well. He has a couple of minor corrections he'd just like to take you to first, and then we'll work through the summary statement.
Good morning, Commissioners.
Morning.
Good morning, Mr. Dent.
Yes, if I could take you to paragraph 341 of my evidence, which I think is page 94 of the applicant's evidence agenda.
Hang on, paragraph. What was the number again, please, Sean?
Paragraph 341.
Right. Yes.
Should start right at the bottom of the page there and goes over onto page 95. In that paragraph, I've referred to the proposed residential unit having 5 bedrooms, and that should state 6.
Oh, yes.
And then if I could take you to Appendix A of my summary statement, which is the recommended conditions of consent. Condition 9. There's a cross-reference in the last line to condition 10. I believe that should refer to conditions 4 and 5 instead.
So planting on the reserve, condition 9.
Yes, that's right.
Yeah.
And the final line includes a cross-reference to condition 10.
Yes.
That cross-reference should be to conditions 4 and 5.
Yeah,
Okay.
got that.
So to my summary, I'm happy to take paragraphs 1 to 3 as read. Commence at paragraph 4. The proposal involves construction of a replacement residential unit and new attached garage, which occupies a footprint of 1,176.74 square metres with a total gross floor area of 2,027.979 square metres. In addition, construction of a separate single-level accessory building with a footprint of 453.96 square metres is also proposed. 67% of the proposed residential unit will be subterranean. The proposal involves large-scale earthworks, predominantly for the basement level excavation, and the cut material will subsequently be deposited on site. In addition, a substantial ecological enhancement and mitigation planting plan has been proposed with 8,082 square metres of native tree and shrub planting proposed, a significant amount of which has already been implemented. Relying on the expert reporting by the applicants and council's experts, it is my opinion that the proposed development, if undertaken in accordance with my recommended conditions, will not have any significant adverse effects in terms of construction noise and vibration, erosion and sedimentation, infrastructure servicing, geotechnical considerations, and natural hazards or traffic generation. The potential effects on the landscape character and values of the ONL which might arise during earthworks and construction and as a result of the proposed replacement dwelling have been assessed. Relying on the expert evidence of Ms. Smetham and Mr. Murray Orr and my own opinions of the perception of visible construction and earthworks activity from a small number of viewpoints, I consider there will be a minor but temporary adverse effect on landscape character and visual amenity of the ONL during the construction period. I note that the bulk earthworks will be undertaken within approximately 3 months of the site set out, and Mr. Murray Orr advises that the exposure of the portal locations will be left until the last stage of the bulk earthworks to avoid works on the east-facing slope for as long as practically possible. The earthworks and construction footprint will continue to diminish in scale over the total construction period and will be subject to staged remediation planting. In terms of the overall effects of the proposal on the character and values of the ONL, I have relied on the expert evidence and reporting of Ms. Smetham and Ms. Malsop and conclude that the development can be absorbed into the landscape with less than minor effects once the mitigation landscaping matures. In coming to this overall conclusion, I've had regard to the existing environment, which includes the existing 2-storey residential unit, associated curtilage, and residential activities. I consider that the proposed built form and domestic curtilage will have a similar visual presence to the existing environment, and that this is a relevant consideration in the assessment of the effects of the proposal. In terms of the relevant objectives and policies, it is my opinion that the ODP provisions have minimal weight. No relevant rules under the ODP are considered operative. All rules triggered under the PDP, with the exception of the maximum 500 square metre ground floor area standard, which has no corresponding rule in the ODP, are beyond appeal. Accordingly, I consider that the objectives and policies of the PDP are most relevant to consideration of the proposal. Overall, I've concluded that the proposed development is generally consistent with the PDP objectives and policies. I have acknowledged the proposed built form is not reasonably difficult to see as required by policy 6.3.3.1. My opinion differs to the expert opinion of Ms. Meetham, whereby she concludes that it would be reasonably difficult to see based on her knowledge of the site and visibility of the existing residential unit, visual simulations and proposed mitigation. While I accept Ms. Meetham's overall opinion that the proposed built form can be absorbed into the landscape, my opinion is that the proposed built form will not be reasonably difficult to see in the strict meaning of the words. I consider that it will be visible on the site, but when compared to the existing environment, the proposal will not be significantly more prominent in the environment. I've also acknowledged that in terms of policy 6.3.3.5, the proposed development, and in particular the landscaping, will diminish the remaining open character of the site that presently exists rather than maintaining this character. Notwithstanding, this change to a more natural character is consistent with the transition occurring in the area through natural regeneration of planting of native vegetation by the Te Kākano Trust on the adjacent council reserve. With regard to the conditions of consent, I attached two versions in Appendix B of my evidence, one being the track change version of the conditions from the Section 42A report, and the second being a clean, untracked version that is more easily readable. I've attached the clean version with two minor amendments as Appendix A and recommend this set is utilised for discussion during this hearing. In terms of explanation of the changes to the conditions from those in the Section 42A report, I provided a brief summary at paragraph 362 of my evidence. This summary is, in my opinion, self-explanatory and outlines that most changes relate to incorrect plan references, typographical errors, insertion of timelines for notification of works to council and audits of erosion and sediment control mitigation, and removal of unnecessary duplication of conditions. However, I will specifically comment on the changes to landscape condition 4 and the construction noise and vibration conditions 18, 20 and 45. In regard to condition 4, I've made a slight amendment to ensure that the final stages of planting, which are areas E and F, have a time limit specified. The landscape staging plan currently states that these are to be completed post-construction, and I've specified in the condition that these should be completed in the first available planting season following construction to avoid any doubt over the timing of their implementation. In regard to condition 18, this requires preparation of a construction noise and vibration management plan. The condition of consent in the Council's Section 42A version imposed hours of operation for rock breaking, concrete floating and craneage, and heavy vehicle movements that were inconsistent with the recommendations in the Acoustic Engineering Services report and the recommended conditions by Council's acoustic expert, Mr. Grimes. My condition has simply been altered to align with the hours of operation recommended by the respective acoustic experts. I also noted in the preparation of this summary that in the fourth line of the condition, the words "in accordance with the New Zealand Transport Agency State Highway Construction and Maintenance Noise and Vibration Guide, version 1, 2013 remain. I consider that these are unnecessary and do not reflect the wording of the AES and Council experts' recommendations, and they've subsequently been deleted from condition 18. Condition 20 in the Section 42A version of conditions was a direct repeat of the construction vibration condition from the applicant's previous consent, RM181171. The standard and associated table referred to in the original condition is not consistent with vibration standard listed in Chapter 36 of the PDP, which the activity is recommended to comply with by both AES and the Council's acoustic expert. Accordingly, I've amended condition 20 so that it adopts the standard and appropriately corresponding table that has been considered by the acoustic experts. Condition 45 has altered the hours of operation for earthworks and heavy vehicles such that they are consistent with the recommendations of both AES and the Council's acoustic expert. The revised hours of operation are also consistent with those referred to in proposed condition 18, which requires the development of a construction noise and vibration management plan. In conclusion, the proposal will have minor adverse effects on the landscape and visual amenity of the ONL during the earthworks and construction period, but these will diminish in significance as the works progress, as outlined by Mr. Murray Orr. Both Ms. Meatham and Ms. Malsop conclude that the ONL values can be protected once the proposed Indigenous vegetation has matured. Temporary environmental effects such as noise, vibration, dust, and sedimentation can be avoided, remedied, or mitigated through recommended conditions attached to my evidence, which include requiring a comprehensive environmental management plan, a construction noise and vibration management plan to be developed and certified. No adverse effects have been identified in terms of infrastructure servicing, access and hazards, land stability, subject to standard engineering conditions I have included. Accordingly, it is my opinion that the proposal represents appropriate development within the ONL and that consent could be granted subject to my recommended conditions. I'm happy to take any questions from the commissioners.
A brief quick clarification. Your latest set of proposed conditions, have you had discussions with council officers about the conditions since their report came out? I'm not saying you had to have, but just out of interest.
No, I haven't had any conversations with Ms. Walker.
Okay. Yeah, I just raised that matter because at the conclusion of the formal hearing, our normal practice is to ask for the parties to, regardless whether consent is granted or not, but to have an agreed set of conditions if possible. So that's fine. Okay.
Yeah, thanks, Mr. Dent. I just have a few questions. Can I just, you went through some clarifications before. Can I just check on one clarification or just it may be a typo? In paragraph 10 of your evidence, you refer to planting over an area of 8,082 square metres. And then in paragraph 58, you refer to it as 6,082. And I'm just wondering, have I missed something, or is it was just a typo?
Was that paragraph 58, the second reference?
58 versus 10.
I believe paragraph 58, that is a typo. The correct number is 8,082 square metres.
Just wanted to ask you a question on the structure of your evidence, and just for the first time I've actually ever seen objectives and policies first. I was wondering if there was any reason behind that. Usually it's effects first and then objectives and policy, and I was just wondering if you can fill me in on if that's what we've seen in the future.
I was provided a template structure for my evidence, which suggested doing the objectives and policies first. That's the only reason for the order of how things were laid out.
Okay, no, thank you. I may have missed something in my reading, but I have not ever seen the peer review from Mr. Grimes from Council's Acoustic peer review, and I'm just wondering, Bob's looking at me a little bit confused. Just wondering if that can be made available. It might be that Council can just give it to us, but it's certainly not in the Section 42A report with all the other officers' reports. That's just something that either the applicant can provide to us, or I'm sure Council will provide it to us.
Yes, I have a copy. I can make that available.
Thank you. Mr. Dent, what was the existing consent that has gone through the judicial review? What's the current status of that application? Has it been withdrawn?
To my knowledge, it hasn't formally been withdrawn. My understanding is that the options available to the applicant were to have council progress the Section 95 assessment again in light of the court's decision, or alternatively to embark on a fresh application. And that's clearly what the applicant's chosen to do in this case. But I'm not aware of any correspondence to the council formally withdrawing that previous application.
And it's maybe a question more to Mr. Leakey, but does it have any implications for us that the two consents sit there side by side, or?
No, and it's something I can address in closing, but just as a signal, as that consent was granted, in a way, once it was granted, it did away with the application because the consent had been granted. The High Court overturned both the notification decision but also the substantive grant of consent. So from my perspective, you're really coming at this with a blank sheet of paper with the new application, but I can address that more formally in closing if that assists.
Okay, thank you. Mr. Dean, I wanted to just understand the assessment matters. The preamble to the assessment matters of the PDP has a little spiel about existing planting, and it may be worth you opening it up if you can. And it's changed a little bit, the wording. It used to be just from the road under the ODP, and I think it was from memory designed to prevent people from just planting hedgerows out the front of their properties and then 5 years later coming back and relying on that hedge to screen the dwelling. And then under the PDP, I just noticed there's a wording change, not only from the roads, which is not really a matter of concern with this application, but the public place. Those words have come in for the public place, and it's the way I read it, it's all about if your planting was established after 2002, that planting that's on site can't be considered beneficial to the assessment matters. And I just wondered what your understanding is, that planting, what your understanding is of that assessment matter and what we can and can't consider in terms of that existing planting on the site and on the reserve.
Could I just ask you, please, Commissioner, to direct me to exactly where that statement is?
Of the ONL, district-wide, and it's the very first part of the assessment. I don't actually have it in front of me.
Sorry, are we referring to the ODP?
PDP.
PDP, yes.
PDP, the assessment matters, and there's two sort of preambles. One is about something about ONL development is inappropriate in almost all locations. And then there's something about it's got to be you've got to be able to visually absorb. I can't quite remember the words, but then there's a second one about relating to existing planting. I can probably think of what it is. I don't think it's in the Section 42A report either. I don't have the copy of the plan.
Commissioner, I may be able to help with that one. I think it's 21.21.2.1.
Thank you very much. And I just what I wanted to know, Mr. Dent, is can we take the existing planting on the site into account in terms of those assessment matters?
If it's 21.21.21 that Ms. Walker just advised of, I believe that applies to the rural character landscape.
It'll be before that.
Apologies, it's 21.21.1.
Yes, the two things there, Mr. Dent, would be really if the trail is a public place, because that's the new words that have been added to the PDP, and then can that planting be considered beneficial in terms of the assessment matters?
I'm just reading that 2121.1.2 at the moment. Bear with me 1 second. So that point B it does say if it obstructs or substantially interferes with views of the proposed development from roads or other public places, it shall not be considered as beneficial under any of the following assessment matters unless the council considers the vegetation or some of it is appropriate for the location in the context of the proposed development. Mm-hmm. So in my opinion, the vegetation proposed is appropriate for the location and context of this site. And if I can just delve into the reason for that in a bit more depth, the adjacent recreation reserve has been subject to native restoration planting by the Te Kākano Trust, immediately adjacent to the site's eastern boundary. In addition to that, a portion of the council's recreation reserve, if you have access to the council's district plan web mapping application, you'll see there's a strip of zoning from the proposed district plan that is nature conservation zone. And the purpose of that nature conservation zone primarily applies to open space and recreation areas that border lakes and rivers or are recognised for their natural, ecological and landscape values. And so in my opinion, I think the vegetation proposed in the context of this development sits well with the adjacent recreation reserve and proposed district plan zoning.
Thank you. Could you just sort of explain a bit more about what's happened with I think it's the trees that are actually located on the reserve issue? I just want to understand that issue a little bit more.
So when the application was, when the 2018 application was lodged, I believe the landscape plans at the time showed the site boundary fencing, and that was presumed to be the correct boundary, and all the planting was shown within it. The latest landscape plan, and I didn't recognise this until after lodgement of the application, but the latest landscape plan shows the existing deer fence, and then it also shows a property boundary line in a very fine hatching setback. And it was about the time I undertook the site visit with the previous processing planner, Ms. Gathacole and Ms. Melsop. I noticed that discrepancy, and via Triple Star, we got a survey undertaken to pick up the correct legal boundary of the site and just confirm which of those trees and existing planting that the applicant had undertaken were on their site or the council's recreation reserve. Once we became aware of that boundary issue, I initiated discussions with council's Parks and Reserves Department as to how we might resolve those infringements.
Thank you. You would have heard my question to Mr. Leakey about the sort of conflict in the plan between natural character and maintaining open character, and I just wondered if you had anything to add to what Mr. Leakey had responded to.
Yes, it's quite interesting how those objectives and policies lie. To me, it doesn't appear that there's any specific direction in the plan as to which should carry more weight. I think it needs to be considered on a case-by-case basis in the context of each application. And in this case, yes, the site you could consider is open at the moment, but again, when you consider the context and the Indigenous vegetation planting undertaken by the Te Kākano Trust, the proposed district plan nature conservation area zoning along the lakefront, and also there's a number of objectives and policies throughout the regional policy documents as well that talk about enhancement of ecological biodiversity and nature conservation values. I think the transition from what is currently an open character to a more natural character is appropriate in the context of this site and this application.
Thank you. Oh, and just, I understand the difference in opinion between you and Ms. Smeaton about that you acknowledge that you don't believe it will be reasonably difficult to see. I just wanted to make sure I understand what your conclusion is on that policy. It's 6331, and in your evidence you don't seem to land specifically on a conclusion. I think over the page, I'm just trying to find where it is. I just wanted to understand how you see that proposal sitting with policy 6331 and what your actual conclusion is. I think it's in paragraph 116. You do state your position, but I just didn't specifically see it. And I just wondered if there was a difference against, 112, paragraph 112. I just wanted to understand what the final position is. All the other paragraphs have a conclusion underneath them apart from that one.
So is paragraph 112?
112. It starts at 110, sorry, where you acknowledge that you've got a difference of opinion, but I just couldn't see a closing position on the actual policy.
Yes, so
acknowledging that paragraph 116 does finally state where it is, but I just wondered if there was, just wanted to be really clear what it was.
So my opinion, when you look at the strict sense of those words, reasonably difficult to see. My opinion is that the proposed built form won't achieve that particular policy. I have had some discussion with Ms. Smeaton about it, and the policy doesn't provide, I guess, direction as to whether from every possible viewpoint it must be reasonably difficult to see, or if it's not reasonably difficult to see from one viewpoint, whether you're inconsistent with it. I've taken the approach of looking at the proposal from what I consider to be the worst case viewing point, which I believe is viewpoint 12 in Ms. Smeaton's visual assessment or graphic attachment. That's viewing site is on the lake from approximately 430 metres out, I believe. And in my opinion, it shows that the proposed built form will be clearly visible. Likewise, I also consider the existing residential unit on the site to be clearly visible in that viewpoint as well. And that's why I come to the conclusion that the proposal isn't consistent with that specific policy.
I take it as butting in here, but I take it that that opinion is based on what it would look like in the longer term, not simply while planting gets established, but it is a long term.
That is my long-term opinion, yes.
Okay.
Oh, that was all I had, Mr. Dent. Thank you.
Just a couple of quick things. One of the submissions has raised the issue of, which is an interesting one, in view of the, we acknowledge the efforts the applicant has put into planting and the association with adjoining planting efforts of other landowners. It has the possibility of a covenant being explored in terms of restricting any further development on the site and or removal of native vegetation or the indigenous vegetation that's being proposed. Is that something that's been put past the applicant at all?
I have touched on the submitter's comment about a no further subdivision or development covenant within my evidence. It's my opinion that the proposed district plan provisions are strong enough that in any further development on the site in terms of built form would be at least a discretionary activity, and the same with subdivision, that the proposed district plan provisions are strong enough that if such future development was proposed and it was inappropriate, it could be declined without the need for a covenant. In terms of a covenant to protect the landscaping that's being proposed, that's not something I have discussed with the applicant. The conditions of consent that I have recommended in Appendix A do require the landscaping to be maintained and irrigated in perpetuity. But in short, no, I haven't discussed a covenant option with the applicant.
Okay, good. Now, one of the things that perhaps has drawn attention to this application, perhaps to slightly some greater degree than what might otherwise be the case, is the extent of earthworks. I noticed a mention was made of the George application, which is an interesting one for me because I was the commissioner on that one, RM210542. But I think looking at that, it does emphasise that this, even allowing for the fact that it's replacing an existing dwelling, it does emphasise the scale of this proposal. In the case of the George application, the earthworks were 1,910 cubic metres, and this one is 40,000, which is 20 times as much. It is I think it would be fair to say, wouldn't it, that the scale of earthworks involved here for a dwelling in the ONL is certainly right up at the very top end of the scale, one would have thought.
Yes, the earthworks are a substantial scale, but as described by both Ms. Meatham and Mr. Murray Orr as well, the initial stage of bulk earthworks, that first 3-month period, the majority of that's going to be the excavation of the basement level, and Mr. Murray Orr's explained how it's not intended to excavate out onto the lake face or the eastern face where the proposed portals will be until the vast majority of those basement excavations have been completed. It's my opinion that most of those excavations will sit behind the lip of the current terrace and not be particularly visible, and the majority of the earth fill is going to be deposited behind the ridgeline to the west and out of sight of the more prominent public places being the lake. There is also a fill area in that northeast corner, but both the fill areas will be hydroseeded immediately after that fill's been placed. So the actual extent of earthworks that will be visible at any one time will be different to when you just look at the two-dimensional earthworks plans, and also quite importantly different from the previous proposal. Not only has the overall area of earthworks decreased by about 14,000 square metres, but the existing amenity trees located to the south and sort of southwest of the proposed residential unit will also provide, in my opinion, screening of the accessory building excavations, which Mr. Murray Orr took you through, the sort of long cut face to the south. And those existing trees can be seen to some degree in the visual simulations, particularly for viewpoint 12, again, in Ms. Meatham's graphic attachment.
So you're talking particularly about the area in front of the where the portals are, or below the portals?
No, at the essentially existing ground level. Perhaps if I could take you to the Landscape Plans Commissioner. Probably the best one is the existing and proposed planting areas, the staging plan.
Is that 20?
22.
22.
Okay, got that.
So if you can see where the proposed driveway comes in and extends right to the south of the proposed accessory building.
Yep.
Again, to the south of that driveway, you can see there's two rather large clusters of existing amenity trees. Ms. Smeaton may be able to correct me, I believe they're silver birch. In the previous proposal, the 2018 application, those trees were all proposed to be removed and earthworks were intended to extend right through that area and create a large amenity lawn. That's changed with this proposal. Those trees will stay in place and I believe will provide some screening to where that earthworks cut for the accessory building will be.
Okay. Yeah. Yeah, I think at a detailed level, it's quite a complex site, and I apologise, you haven't had the chance because I was away for some time to actually do the site visit. I expect if we had the site visit first, it probably would have been easier to understand this, but that's helpful. Thanks very much.
No, I don't.
Well, at this stage, I don't have any further questions, Mr. Leakey, so.
Thank you, Commissioner. Well, with that concludes the evidence aspect of the applicant's case. We've got a few points there to look into for you, but we will pass back to you. They're just a signal, if the commissioners are minded, I think there's a few points there that would benefit from some consideration and potentially a short written closing submission. So just to signal that now, it may fit nicely if the commissioners are undertaking a site visit later in the week anyway, that the hearing presumably would remain open for that time. So just to signal that now.
Yes, that'd be my expectation. It's normal practice anyway that we ask the applicant and the council to confer over conditions, and we'll obviously come on to that a bit later as well. One thing I will raise with you now, but the council may have already contacted you about this. Ms. Sinclair and I expect to be out at the site. We'll try and visit the site itself first, in other words, drive in. After Friday morning, we'd be there about 8 to 8:15. If we could just, I don't know whether there'd be anybody out there on the site, but if we could see two of us wandering around, or he or she sees two of us wandering around, as long as they're happy and we can drive in and not get hit by a flying aircraft or something, that would be good.
Yeah, no, that's fine. We'll make sure you're safe, and I'll liaise with Ms. Walker just to make sure that any comms that you need from our end you have, but we've let the client know that will be happening on Friday, so that's fine.
Thank you.
Just to confirm, for the record and for submitters, we'll also make sure that there's no one that our client's not on site when you're there. So it'll just be yourselves.
Thank you. Thank you. Well, at this point, we'd normally call first submitter, or the only submitter who's appearing today is Mr. Howarth. Is Mr. Howarth there?
I can see Mr. Howarth on my screen, but you may be unmuted, Julian.
We can't see him here, but I mean, we can proceed with him if he's happy to proceed now.
Hello.
Oh, Mr. Howarth.
Did you get that?
All right. All right. So are you happy to proceed now?
Certainly, sir. Yes.
Okay, right. Well, we've got the floor at the moment, so feel free to grab your submission first. Just bear with me for a second.
Sure. You should have a submission and evidence, sir.
Yes. Now I've got submission. I've got your evidence here, which is a photograph in the front of it.
That's right.
And a statement. Happy to proceed with that. That would be good. Thank you.
Thanks, sir. Good morning, everybody. I've been watching a New Zealand falcon flying around my washing line while we've been doing this, which is impressive. My evidence is I'm familiar with the code of conduct for the court. I've done a lot of court evidence, and I believe this evidence is prepared consistent with that code of conduct. I'm just going to go through the evidence with a few key points and emphasising a few key points, and commenting on some of the things that we've heard this morning. Going to paragraph 8 of my evidence, I say there that I've attached a photograph taken from my boat back in February. And I believe everybody has a copy of that photograph somewhere in front of you. Moving on to paragraph 10 of my evidence over the page. I consider that the existing residence does not meet the reasonably difficult to see criteria required to be met by PDP policy 6.3.3.1. Now here I agree with Mr. Leckie that the existing building is not reasonably difficult to see, but only to the extent that it's getting close to being reasonably difficult to see, as you can see in my photograph. Now that was taken on a sunny day, and the existing house has become quite embedded into the landscape. The colours are good, and the vegetation is very good. It's started to really hide it to a certain extent, while it still remains. It still doesn't satisfy that criteria of reasonably difficult to see. That's my opinion. At this stage, I'd like to take you to the attachment Mr. Dent just mentioned, which is viewpoint 12, which is page 263 of the evidence that we got from the applicant yesterday, but it's labelled page 261. Viewpoint 12. Have you all got that in front of you?
I have, yes.
Okay, I'm still looking there. Okay, we're all there now.
Viewpoint 12, sir, yes?
Yes.
Okay. Now, I'll come back to that. I just thought it was good to get it in front of you then. The planner's report accepts that the new residence will be contrary to the reasonably difficult to see criteria. Yeah. Now, so, and I concur with the planner there as well. So both myself and the planner believe that the new residence, when it's built, even after 5 or 10 years of, as you can see from viewpoint 12, even after 5 or 10 years of the vegetation growing, it will remain certainly not reasonably difficult to see. The planner says the new residence will be more prominent than the existing residence. The planner's report is very clear about that. That's paragraph 16 in the planner's report. Now, in my opinion, the planner makes it plain that it will be more prominent. In my opinion, the visual adverse effects of the residence will be significantly greater than the existing building on the site. So in other words, the visual effects of the new building will offend and fail to meet the crucial policy 6331, reasonably difficult to see. It will fail to meet this crucial criteria by a significantly greater amount than the existing building. Yeah. Now, and you can see this if you look at the viewpoint 12. Now, viewpoint 12 is taken from way out in the lake, 430 meters, I think Mr. Dent said. If you blow that photo up a bit, in other words, replicating the fact that you're sailing a bit closer to the shoreline, the building gets more and more visible. You can zoom in on that photo a little bit, like I have in my computer to the left of me here. And the applicant's evidence downplays the visibility somewhat because it's so far out in the lake. If you look at it by zooming in a little bit, the house becomes, the new residence becomes well, very prominent in the landscape. Yeah, and I have to say that I'm very surprised by Miss Smeatham's comment that she didn't think that this building is reasonably difficult to see. I mean, that she thought this building was reasonably difficult to see. Yeah. Now, the key point here, and I know I'm going on about the reasonably difficult to see, but the key point here is that the new residence does not meet this reasonably difficult to see criteria. Any new residence that is consented should, let me go back to how I prefer to phrase it, where an existing residence does not meet this reasonably difficult to see criteria, any new residence should not be consented to that fails this criteria to a greater extent. Because this is I accept that this is only a single policy in the plan, but it's an absolutely crucial policy, and it shouldn't be given the same level of importance as all the other policies in the plan. This is a policy that is required to be met. It's a policy that's required to be met by the plan, and it's been introduced into the proposed district plan. In Wanaka, we didn't have the reasonably difficult to see criteria in the operative district plan. It's been introduced into the proposed district plan, and it's operative now. It's not challenged, and it's an absolutely key policy that needs to be met. Moving on to paragraph 16 of my evidence, it remains my opinion that this application will result in significant additional adverse cumulative effects in this very sensitive vicinity. Remember, we're talking about lakeside outstanding natural landscape here. So I disagree with the applicant where they say this will have a neutral cumulative effect. I think that's completely wrong, completely wrong. And going on to my paragraph 20, I talk about the plethora of development within ONL means that there is now seldom, if ever, a view from public places of ONL in this vicinity that does not contain development. Now, because of this situation, because so much development has been permitted in the past, the Environment Court has made this vicinity, this landscape, all the way to Glendhu Bay, a priority area. Now, the way that these priority areas are defined is through development pressure. So the Environment Court has accepted and mapped that this is an area that is under development pressure. And this is an area, because of that will have a landscape assessment carried out in June. And these landscape assessments will be introduced as a plan change to the proposed district plan in June, and will probably become operative subject to appeals later in the year. So that this is a highly relevant and key point, that the Environment Court has already and very recently said that this area where the subject residence is proposed to be is within a priority area that is already under development pressure. So whether we should be allowing more cumulative effects in a priority area under development pressure is, well, in my opinion, that shouldn't be happening. Now, moving on to temporary effects, and I put that in inverted commas. My paragraph 22, the application says that the proposed development will involve only a temporary effect. I consider that highly visible development taking place over several years will not be a temporary effect. Now, according to the information we've got, there'll be 2.5 years construction, demolition and construction, and then 2.5 years for the mitigation planting to start to take effect. Now, that's 5 years before we have any mitigation on this very big development. Yeah, that's half the life of the district plan. Half the life of the district plan. That's a temporary effect. Yeah, no, I don't buy that, and I don't think the commissioners should buy that either. I listened to Mr. Leckie say that there's a legal opinion that temporary effects could last for 6 years on the roading, but here we're talking about a very prominent site in outstanding natural landscape, visible from Wanaka town, visible from Ruby Island, visible from the lake, visible from the Waterfall Creek car park, which is a very, very popular place for tourists. I don't think you can compare that with the effects of roading, which takes 6 years, and I'm not sure there's any comparison you could draw at all there. And finally, I'll just comment on the question that was asked at the end there by the commissioners, which is about the covenant, which the Society requested in its submission. Now, I heard the answer that came from Mr. Dent, that the district plan is strong enough to prevent any development on the subject site. Well, let me turn that round. If the district plan's so strong that he thinks that they can't get any development on this site, why not offer the covenant then? They're not losing anything. They've accepted they can't get any more development on this site. So, I mean, the Environmental Society would see that as a very strong positive if a no development covenant was offered on the whole of it, in perpetuity on the whole of the rest of the site. Thank you, sir.
Thank you.
Thanks, Mr. Howell. I did have some questions around Chapter 3 and the priority areas and the framework, and you've explained those to me, so thank you for that. Just there was a couple of smaller questions. Where you referred to your wetland that is protected on the site? Do you know where? I hadn't seen that anywhere. I just wondered if you could direct me to the area on the site map. Where is the wetland?
Well, I don't think I can, because it would, the technical problems I would have in doing that, and my computer would, I think maybe I'll be happy for the applicants to address that in their closing, if you don't mind. Yeah.
I just wanted to understand where it was.
Yeah, I just don't have the maps in front of me. It would be too complicated because I didn't print them off, and it would mean going off the page, you know, and yeah.
Oh, and the other question I had is you referred to the Waterfall Creek track as part of the Te Awaroa Trail. Is that? Is that the track that you are saying?
I think it is.
Yes, the track that runs along the side of Lake Wanaka and along the side of the subject site, towards the lake side there. Yes, that's part of Te Awaroa. Yes.
It goes on up the Motatapu, doesn't it? After that.
That's right. That's correct, sir. Yes. Yes. Have you walked it, sir?
Only as far up the Fernburn to the first hut. I haven't walked the whole.
Oh, okay. Yeah. I've been there, sir. Yeah.
And the last part of it is there was just a sentence that it just finished with an and. It was page 5 of your submission, and it was about halfway down, and it just the sentence is incomplete. I just wondered if you had anything else that you had meant to include and hadn't included.
Can you read it to me, please? Because I've only got the evidence in front of me.
Find it, so bear with me. Submission. What would that be? It's probably a submission, actually, with that. Page 5. Yeah, it says, it was just after the Te Awaroa comment. It says, the width, height and scale of the proposed residence means that it is likely to be significantly more apparent in the landscape when viewed from public places in the vicinity, such as the Te Awaroa track, Lake Wanaka and the Roy's Peak track, and I just wanted to check.
Oh, I think I just left that hanging, and maybe I was going to add one more public place onto that, and just forgot to do that. Yeah, I think I listed them just now from the Waterfall Creek Car Park, Ruby Island, Teorea Track, even from town. I think this site will be visible from town under construction.
I'll just add those in that submission.
Thanks.
Oh, and you raised an issue that the application was assessing effects on visual amenity as opposed to effects from the visibility on the ONL. I just wondered if the evidence of the applicant has corrected this for you, or is it something that is still a significant issue for you?
No, that's been addressed in the evidence that I've seen sufficiently. I mean, I don't necessarily agree with the conclusions they reach, of course, but no, they've addressed it from that point of view.
Oh, that's all I had. Thank you very much.
Thank you.
Now, you probably heard in the earlier questioning, following up that point I think you were making about, which is critical, I think, your evidence relating to, we've got an existing dwelling there which has a degree of visibility. I think we both agree on that. The applicant has argued that if you look at viewpoint 12, that's what I think they call the east face of the facade, eastern face. They've argued that the visual effect will be less because it's shorter. You've got a shorter building facade. I think it's 13 metres versus 20 something or other. But it is interesting that if you look at the simulation on viewpoint 12, it is, you have made an interesting point there, because if that simulation is accurate, if you look at the bottom one there, the black outline of the proposed building. Yeah,
yes, I'm looking at it. So.
And then you compare that to the existing dwelling, which is longer. But if this is an accurate simulation, then it certainly gives the impression that the proposed dwelling may in fact be more visible. I think it was a comment that Ms. Melsop had made in her landscape evidence for the council. So that's a key point from your evidence.
Yes, and as I said before, that's taken from a long way out in the lake. If you zoom that photo, like I've done on my computer here, so that you were, say, 200 metres out in the lake, the building becomes very prominent and definitely more visible than the building that's there at the moment. You see the way it breaks the ridge line? No.
So we'll also be taking, obviously we need to take account of what is a reasonable temporary effect. I agree with you to the extent that the comparison with the Transmission Gully motorway project is probably not a good one in terms of temporary effects, one would have thought. It's quite different to a single dwelling.
Yeah, and different landscape as well.
Right. Now you made mention before, this is my final question for you, is the environment courts issue decisions, as you're aware, in a series of separate decisions, and you made reference to this area being identified as a area under pressure. Now, is that in one of their more recent decisions? I'm not familiar with it personally, but it's something I can raise with the council.
Yes, I've been involved in the district plan for 8 years, and I've been involved in all of those decisions, including going to all the court hearings, cross-examining and so on. Yes, there are a whole series of decisions, about 10 decisions on the policies and the objectives in chapters 3 and 6. And then there's a decision pending on chapter 21, which contains the assessment matters. And that also, no, it was part of the chapter 3 and 6 decisions, which link in with these landscape studies. So those decisions, the chapter 3 and 6 decision, will link in with these landscape studies, and so those policies and objectives feed through to the landscape studies, which will be introduced into the plan in June. Yeah, these are all very recent decisions, sir. Yeah.
I'll follow that with the council. I presume it must be one of the decisions on chapter 6, I assume. I'd just like to know, I realise that we don't have what might be contained in June before us yet. We can't put any weight on that, but I am interested in what the court may have said in that decision on chapter 6.
Yes, there's about 10 decisions, sir, and you should probably get hold of all of them, really, and flick through them, because there was a developing process as we developed the policies and objectives.
Yes, I understand that.
I don't.
Okay, well, yes, well, thank you, Mr. Howard. That's very helpful.
Thank you.
Thank you. Thanks.
We can go back this way.
Erica Walker, council. Get on there.
Oh, gosh. Not sure what to do.
All right, well,
Should I go ask Trish?
I'll do it.
Okay. Just some slight technical difficulties from our end.
All right, it happens to the best of us, Commissioner.
You can just ask if she wants to take a break before she.
That's what we're going to do. We just want to talk to her briefly and say, well, we're proposing that we take a lunch break.
Yes.
If that's convenient.
Yeah.
And it gives the council time to get prepared.
Yeah, you can ask her through, but she's listening. She's just not here herself.
Okay. Ms. Walker, we can't quite see you at the moment, but we'll be seeking your response to what you've been hearing today. Our thoughts at this stage is to take the lunch break, and that will also give you the opportunity to gather your thoughts before coming back with your responses and what you've heard and for any questions we may have. Now, are you placed to do that?
Yes, that'd be great, Commissioner.
Okay, no, that's fine. So, 12:30, what should we do? Is about 1:15, would that be work for you? Give you enough time?
Yes, that suits me.
Okay, that's fine. All right, well, on that basis, we'll adjourn the hearing now and reconvene at 1:15.
Thank you, Commissioner.
Thank you.
Hello. Everybody hear us clearly? We'll reconvene the hearing. Ms. Walker, I think it's your opportunity to respond to what you've heard this morning.
Yes, so I'm still standing by what I've written in my 42A report regarding those temporary effects and permanent effects. I still think that the proposal will be seen from points on the lake and things like that. I do have, I did look through the district plan definitions and found a definition for open space regarding that question around what is defined as open space, which is defined as not substantially occupied buildings and which provides benefits to the general public as an area of visual, cultural, educational, recreational, amenity values. So I think I would take open space to mean leased buildings and vegetation. Native vegetation can mean open space.
Right, that's the point. I think my colleague was asking that this morning, so it doesn't, if that is correct, then there's no conflict with any issue of planting natives instead of planting tussocks, as it were. Okay.
Thank you.
Thank you.
Oh, and sorry, Ms. Walker, was that from the definition section of the PDP?
Yes, it is, yeah.
Thank you.
So apart from that, have you got any other comments you want to add at this stage?
No, I do have on the Ms. Malsop, the landscape architect, and Mr. Jones, our engineer, if there are any questions regarding engineering matters, as well as landscape questions to Ms. Malsop. So nothing from my perspective to add at this stage.
So, Ms. Malsop.
The landscape architect, yes, probably. Yes.
Yeah, so is Ms. Malsop available by any chance?
Yes, she is.
Okay, well, I think it might be useful for her to be present because there are a few things we'd like to just follow up with her. If that's possible.
Yes, I'll mute myself and Ms. Malsop.
Yes, I'm available here. Can you hear me all right?
Oh, yeah.
Oh, there you are.
We can see you.
Thanks, Ellen.
Yes. Sorry, I'm having a few technical difficulties. I don't know if anyone else is either. Your voices are kind of breaking up a bit, so I may need to ask you to repeat questions if they break up.
No, that's
okay,
fine.
I understand that.
I've got a question. Thanks, Ms. Malsop. I see on paragraph 28 of your report, I'll quote you, it says that you're less convinced of the ease to which the proposal will be absorbed within the ONL. Can you just explain what you mean or elaborate on that, or what your concerns actually are?
I was responding to Ms. Latham's landscape assessment and her assessment of the magnitude of effects that would occur, in particular in relation to the assessment matters in Chapter 21. And my assessment was that the magnitude of effects would be, a degree higher than her assessment. I set out what my opinion is of the degree of effects kind of earlier in my review. So that just refers to that difference between myself and Ms. Smeatham in terms of the magnitude of potential adverse landscape effects.
By any chance, did you hear the discussion this morning? I presume you did. Right.
Yes, I've been listening.
Now some of that is sort of trying to compare the extent to which the proposed dwelling might have greater visual impact than the existing dwelling. I think if I understood your evidence correctly, you felt that the existing dwelling actually was a bit like Mr. Howarth. You thought it sort of sat in the environment in terms of its colour and what seems to be a reasonably fine-grained appearance. It sits in the existing background quite well, relatively speaking.
Yes, yes. It's a particular combination of the exterior colour and the design of the building with its roof line. It's quite steep roof, which breaks up the bulk and mass of the building, particularly as you see it from the lake. That makes it particularly recessive in its particular environment, and the vegetation that's grown up around it helps in that regard to integrate it into that environment. And in comparison, the new proposed dwelling, while it might have a narrower eastern facade, it's further forwards on the site, it's slightly taller, and the very stark rectangular shape of the that would be visible enhances its perceived mass and makes it more visually prominent. As I've said in my review, the exterior materials and the colours help to reduce that impression, but it's still my opinion that it would be more prominent than the existing house, particularly from the lake.
Yes, that was going to be my next question. In terms of what you've just said, is that I presume you have Ms. Smetham's report with you, or do you? The landscape assessment.
So Ms. Smetham's report.
Yeah, Ms. Smetham's report. Do you have that with you?
Yes, I do. Yeah.
Could we perhaps look at it's right towards the end, viewpoint 12.
(112).
Yeah, viewpoint 12, existing view and visual simulation.
Yes.
Now, you may recall.
I think particularly from.
Sorry, what was that?
Those closer viewpoints on the lake, the new dwelling will be viewed against that light coloured background of the slopes of Mount Roy, of Roy's Peak. So it will appear on the ridgeline and will be more prominent because of its contrast with the background colour. So from those points of view, and I think the visual simulation tends to make building look darker than what it would be. I think in actuality it wouldn't be as dark as shown in this visual simulation, and there is likely to be some kind of reflection from the windows that are not shaded by the overhanging roof. So those windows would show up to a greater extent than shown in the simulation. But that would depend on the angle of the sun and how much shading the overhanging eaves provided.
Yeah, I understand that. Yeah, it's just that we're pondering those two photographs. Yeah, there's, on the face of it, it does look quite prominent against the background. But you may recall I asked a question this morning about the simulations and how accurate they were, and you'll recall that Ms. Smetham was of the view that this was, she had a lot of confidence in the quality of the simulations, in which case the proposed building does look fairly, well, seems to have a greater visual impact, even if it's a smaller facade, eastern facade, than the existing building. It's almost hard to avoid that conclusion.
Yes, in these closer viewpoints, I think that would be the right conclusion. That would it would be more prominent.
So that's a viewpoint out on the lake. In terms of onshore viewpoints, what's your opinion with respect to that? Just trying to get the right ones now.
It's probably walking along the trail.
Walking along the Millennium Trail.
So perhaps if we go to viewpoint 3.
Yep. Got that.
Which is along the trail to the southeast, but you know, one of the closer viewpoints along the trail to the southeast. So from this viewpoint, you will see some of the earthworks and construction activity. Silver birds will provide some screening, but they are deciduous, so screening will be less in the winter months. And before the mitigation planting has grown up, the building will have slightly more prominence than the existing dwelling in these views. But my view is once the planting has matured, the visual impact will be similar to the existing house. As you get closer, if we go to, I'll just find the right viewpoint, sorry. There's one closer one. Sorry, I've just got to find the right viewpoint.
Your viewpoint 7.
Yeah, similar to viewpoint 6 and Ms. Smetham's attachment. So from those close viewpoints, close to the site and below the site, initially the new building will be visible sticking up above the ridge line. However, as the mitigation planting grows, it should completely screen the building in time. So over a period of about 5 years, should completely screen the building from those close viewpoints just below the site. And viewpoint 7, which is at the lookout on the Millennium Trail, the Douglas fir do effectively screen the site at the moment. I've still got some concerns about the replacement planting that's proposed to replace those trees. I've seen the photos of some underplanting under the Douglas fir, and in my view, it's going to be very difficult for planting in that situation to grow to a height to replace the Douglas fir's screening effect because of the shade and the dryness underneath those trees. But I do think that there is plenty of room inside the site, so inside that line of Douglas fir, to plant a greater number of trees such as beech. It would replace the Douglas fir in terms of screening, but at the moment that kind of planting isn't shown on landscape plans, and I would recommend that additional planting be provided inside the site and inside the Douglas fir to effectively replace those trees if they're removed, because removal of those Douglas fir will really open up the site and make it quite visible from that lookout point and from the track and corner.
It also shows in that viewpoint.
And I'm just a little concerned that, yeah, from viewpoint 7, I'm a bit concerned that if the Douglas fir are removed 5 years, which I think is what the condition requires at the moment, there won't be much replacement screening as yet. In my view, the replacement screening should be at least 3 metres before those trees are removed.
Right, okay. There also seem to be some light coloured trees under both the proposed visual simulation and the existing view, which I presume must look like willows of some sort, but very light green colour. You've got that photograph in front of you there. I'm curious as to what those are. But
yes, there's a willow inside there that you can see, but it is a deciduous tree, so once again it won't provide screening. But that willow is proposed to be retained, so it would provide some screening in the summer months if the Douglas fir were removed.
okay. Yeah. So from what you're saying, it would sound that the primary issue of concern from your point of view is not so much from the landward views as from the lake view.
Yes, I think in the long term, as the mitigation planting grows, it will effectively screen, but it will still remain visible from the lake.
Okay, no, thank you. I don't have any further questions.
No, but I just checked. Commissioner Nixon has asked some of my questions, so that's easy.
I just wondered if I could help you out with the priority area decision, because I've been involved in that as well all the way through. So the decision that sets out that they are development areas under pressure, or why the priority areas have been chosen, is that in decision number 158 at paragraph 9, that's decision 2.5 in the sequence of topic decisions.
Sorry, Helen, we sort of lost you a wee bit there. You said decision 158.
Paragraph 9?
Paragraph 9, yes, and it's decision 2.5 in the sequence of topic 2 decision.
2.5 is the decision?
Yes, I don't know, it seems to have 2 numbers. It's called decision 2.5, but number 158.
Okay.
In the Environment Court numbering.
Okay, yeah, I think we might just obtain a copy of it.
Yeah.
We're probably limited as to what we can do with what the council may decide to do in terms of provisions that might apply in those under pressure areas. But I think it'd be useful for us both to see what the court said about that in terms of areas under pressure. Because that's, I think I'm correct, I've said this morning that the Environment Court some years ago said that this was like a little, it was almost like a sub-zone of the ONL, but it was too small to sort of stand on its own as its own environment, if we use that term.
Yes, that's right. Although they recognise that the Damper Bay to Waterfall Creek Valley had a different character from the remainder of the ONL and was more sophisticated. They did say it was too small to be a landscape in its own right, and also they recognised the sequence of landforms along the edge of the lake, from Damper Bay, Ironside, and that they were an important part of the ONL. So the valley's kind of sandwiched between that series of landforms along the lake edge and the Mount Alpha range.
Yeah. Okay.
That was all I had.
Well, that's
Thanks, Ms. Nelson.
thank you, myself. That's very helpful. Thank you.
Thank you.
Okay, Erica, I think we're back to you again.
Okay, great.
Yeah, that discussion we just had about, is it possible for us to have we don't need the whole decision, but the bit that refers or has any reference to this area? Ms. Millsop was talking about decision 2.5, which I think is one of those sequential decisions of the court. So if we
can supply that through.
Yeah, just to see what they've said. It may not be of fundamental significance, but I think it'd be useful for us to have it as background. Now, Ms. Sinclair this morning raised an issue about the objectives and policies in the plan. Now, the situation we've got with this area now is that no rules are triggered in the ODP, and you've heard the discussion earlier on this morning, one of the first questions. Has the council ever had any legal advice on that? Because I understand there can be a view that if no rules are triggered in the ODP, then the ODP can be completely disregarded, regardless of whether there are still some policies or assessment matters in the PDP that are under challenge. Now, has that issue ever been subject to any legal advice?
I would have to go and do some further background and ask some questions as to whether that's been that question's been asked, but I can supply that evidence that through to you when I find that out. But at the moment, we are looking at the PDP first, and then looking at the ODP provisions and how that fits in. But usually more weight's given to the PDP. So much like Mr. Leakey said this morning, but I can find out for you if there's been some legal advice as to how we're progressing with that.
Yeah, as I wouldn't expect you to sort of spend a huge amount of time on it. I'm just a bit curious about that matter, because I have heard comments to the effect in other circumstances that if a rule is not triggered, especially like Section 9 of the RMA, then effectively the ODP has no relevance at all. Now, I understand from your perspective and from Mr. Leakey's, it's a case of, it's still a waiting case. Even if no rules are triggered, you still have to have some regard to the objectives and policies. I would imagine it would not be very much regard, but there would have to be some. Okay, that's fine. Now, in terms of conditions,
yes.
From the question this morning to Mr. Dent, I understand that those haven't been discussed at this stage. So are you at this point wanting to comment on the conditions that he's raised?
Yes, I would like to work with Mr. Dent, obviously, in getting the conditions aligning. I guess our difference is the hours of operation. I put in as recommended conditions about reducing those hours of operation, mainly due to the effects on neighbours and people using the Waterfall Creek track. Because of the extended nature of the 2.5 years construction, having sort of standard working hours rather than till 8 p.m. at night and early-ish in the morning, just sort of a more standard condition about working hours for those hours of operation. And that's why I chose to include those hours of operation in my recommended conditions.
Yep, okay.
I just had one thing on the hours of operation, Ms. Walker. We got given a submission this morning from Tri-Lane. I just wanted to see their hours. They are requesting 7:30 a.m. to 6 p.m. and then machinery 8 a.m. on Saturdays after 1 p.m. No machinery to be used before 8 and up to 1 p.m. Where do your hours sit with relation to where Tri-Lane sit? Is there still a big difference?
No, so my hours during the weekday are, I believe I recommended, sorry, I'll just find, I think I said potentially 8 AM to.
Off the screen.
We've lost all visuals, but we can hear you, Ms. Walker.
Sorry, have you lost all visuals?
Yes.
Lost all visual.
Technical difficulties.
Yeah. Trish might be listening to us.
So I'll just check on that.
What happened? I want to get my tip. Charlie, we've lost all visual in here. Well, I can see you.
Oh, do you think I've pushed something?
Oh, thank you.
I know what's happened.
Blame me?
Yeah.
All your fault.
Here we go.
Hey.
That's it. Okay. Thank you, everyone. We're now back on deck again.
You just click the internet browser down the bottom.
Oh,
As soon as
did I? Blame me. Sorry.
okay.
Thanks, darling.
I didn't click anything.
Okay.
So it's given me a little bit of time to hunt through to find my hours of operation condition. Yeah, so I've suggested Monday to Saturday, 8 AM to 6 PM, which is half an hour shorter than the tree lane, which they've asked for 7:30. And then Saturday, obviously they've reduced it till 1 PM in the afternoon.
What did you go to on Saturday?
Monday to Saturday, just 8 till 6.
8 till 6, and they want to finish it, they wanted to finish at 1. Okay, thank you. I just wanted to understand where the difference was.
Yeah, and then no work Sundays and public holidays.
And this is the other last question I had was related to Mr. Grimes's peer review. If we could just have a copy of that.
Absolutely, yeah.
Check. Oh, there was one question I had on the objectives and policies, and it was regarding, let me find it, policy, it was in chapter 3, to pull that up. There was just one policy that you hadn't considered, and it was policy 3.3.23. I'll just open up section 42 area report. I don't think that you've looked at it, and I just wanted, if you can just check that, make sure that I haven't mistaken, but it doesn't appear that you've commented on it, and I just wanted to just get your response to that particular policy 3.3.23 relating to cumulative effects for rural living purposes.
Yeah, so if I haven't covered it off in my report, I can make a statement on that now. So in my assessment, I didn't necessarily trigger the use of using the existing environment in a technical sense, but the fact that the site is highly modified and used for rural living and residential purposes. So I think by redeveloping the site for another house, for another residential dwelling, I don't think it adds cumulative effects in a rural setting, because the site is modified as for residential purposes at this point. And I think by providing the amenity planting and the visual mitigation planting, it adds value to the O&L and the from an ecological standpoint as well.
That was all I had. Thank you, Ms. Walker.
Okay, thank you.
There is, oh, sorry, Commissioner, I did want to note Mr. Jones is on the line as a for council's engineer. If you have any questions regarding fire or anything engineering.
I didn't. It looked to me like it was relatively straightforward in terms of servicing and engineering matters. There didn't seem to be any major issues arising there from my perspective.
And I had the same perspective. All I wanted to see if there was any outstanding differences.
Yep.
Okay.
Yep. Very much. Mr. Leckie, I guess this brings us back to you at this stage. Now, you've already indicated you probably will, you will want to issue a right to reply in writing.
Yes, thank you, Commissioner. I would, I think that's a sensible approach. It also allows time for Mr. Denton, Ms. Walker to have a catch up on the closing submission version, if you like, of the conditions. So what I'd propose is that could happen at the same time, and with the aim of us filing our written closing reply and an attached version of the conditions with an update on where Ms. Walker and Mr. Dent have got to by say this time next week, if the commissioners were minded to that deadline, just to give time for that conversation to happen on the conditions. There's not there won't be a particularly long document, the reply, but just to cover off the points raised and also the PDP discussion around decision 2.5 and the priority areas.
Okay, if we just apply a date of just over a week, Friday the 20th of, that sound fair and reasonable?
That sounds fair to me. Thank you, Commissioner.
Ms. Walker, you comfortable with that?
Yes, Commissioner, I'm comfortable with that.
If there's anything or any particular issue anyone wants to raise at this closing stage, we'll adjourn the hearing at this point. As made aware, you're aware, we'll be undertaking a visit to the site this Friday morning, and that'll include the site itself, the Millennium Track, and the surface of the lake.
Just one practical point, Commissioner, which may assist on your site visit. Mr. Dent's reminded me that there is a pedestrian gate to go from the site to the Millennium Trail. So if you did want to go directly, you can do that. It's up near the pine trees that are the conifers that are proposed to be removed. So that there is a gate you can walk through there to get to the viewpoint that the visuals have been prepared from.
Okay, that might be a good solution. So, yeah. And there is a track from the gate up to the top?
Yeah, that's right, yes. Yeah.
Okay.
Yes, I'm fine.
Okay, well, just take the opportunity to thank you all for your contributions today. It's been a very interesting hearing, and we'll adjourn at this point. So,
thank you for your time, Commissioners.
Thank you.
Thank you, Commissioners.
Thank you.